Fail to appear. That was Cecilia was on the underlying matter. That's why. Okay. Going on out in the hallway, but okay, back on the record in the matter of the people of the state of Michigan versus Katina Newton, and the jury is here. I believe we're ready to begin our jury selection. Any issues with the jury instructions that were sent to you?
At this point, no, Your Honor, nothing.
No, Your Honor.
Okay, any preliminary matters before we call the jury in? Any preliminary matters?
No. Your Honor, just sequestration witnesses once we get to that point.
Okay, sequestration of witnesses will be granted. You can bring the jury in. Rise for the jury. I don't think everybody was down there. I think they had some down there as part of the issue. Okay. Let's do this first. I'm gonna remove some of you all and get you in spots at this point. I don't think I got an updated list.
Mine says 19, there's only 18.
Yours says 19, we only have
I
18.
only got 18.
Did we ask the administrator or
Susan Compton.
who's running the agenda? Who were you told to contact?
Hold on.
Stephanie. I think it's Stephanie. My signature. Okay. Let me get Rebecca McMahon over here in seat number 1. Rebecca here, raise your hand. Okay, you're gonna come around this way,
Oh,
this way, ma'am. Benjamin Brook, raise your hand. Is Benjamin Brook here?
I thought that was the guy she sent home this morning.
Yeah.
Because of where he
Oh,
lived.
yeah,
He's a
Hazlet.
resident of Hazlet.
Oh, I see that here. I don't know why he's in our folder. Okay, Christopher Adkins.
All right.
Reynaldo Talit Santana. Elizabeth Tabor. You're number 4. Number 5. Laura Thornsbury. Number 6. Enrique Rosas. Number 7, Jamie Wolfgang Ebby. The rest of you may be seated. Okay. Everybody can fix their attention to the screen. Ladies and gentlemen, I am Judge Kristen D. Simmons, and it is my pleasure to again welcome you to the 54A District Court of Ingham County. I know that jury duty may be a new experience for some of you, maybe not so new since you all just came down from Judge Ward's courtroom. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution have a right to a trial, not by one person, but by a jury of 6 impartial persons. This only happens when I'm doing jury instructions, I promise you that. So you may not see the whole thing because it will require me to keep restarting the show. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in the trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection, which you all are familiar with. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to serve as a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason to do so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have a religious belief against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. Please rise. Raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do so, say I do.
I do.
Thank you. You may be seated. I will introduce my staff to you. Right here is Mr. Nicholas Bigelow. He is my court officer, and to my right is Addie Nash. She's my court recorder. This is a criminal case. It involves 2 counts. Should be 1 count, I believe. Is that correct? 1 count, that's an error, of assault and battery. I will explain that more fully later. This charge has been made against the defendant, who is Katina Michelle Lee Newton. The defendant's attorney is Mr. Dustin Kuntz. Mr. Kuntz, please stand and list any witnesses you anticipate calling in trial.
Thank you, Your Honor. Good afternoon, everybody. I'm Dustin Kuntz. This is my client, Katina. She will be testifying this afternoon. And so boyfriend, Jaquille, Stevenson.
Thank you. And then the assistant prosecuting attorney is Mr. Dale Kaltwriter. Mr. Kaltwriter, please list any witnesses you anticipate calling in trial.
Thank you, Your Honor. Would anticipate calling Officer Zachary Johnson from the Lansing Police Department. Department, and also Karen Lockwood.
Does anyone in the jury box or anyone waiting patiently for their turn to get into the jury box know any of the defendant or any of the lawyers or the witnesses that were just named? If you do, just raise your hand. Who do you know, sir?
Officer Jaquille Johnson.
You know Officer how do you know him?
I used to work for Lakeland Police Department.
Oh, okay. Okay, anybody else? Okay, sounds good. We think that this trial will last for a few hours, not a full day. If you believe that the length of the trial will be a real hardship for you, please let me know. Some of you may have health problems that will prevent you from serving on a jury. For example, does anyone have a medical problem that makes it make you unable to sit for 2 or 3 hours at a time? Or does anyone have any sight or hearing problems? I can't sit for 2 and 3 hours either, so.
I have a bad hip
Okay,
and I can't just sit, I can't be sitting for too long. I have to stand, sit,
okay. And so how long can you sit at a time?
until it hurts.
So
I
you
don't know
you
how
can't
long
predict how that works, correct?
Right.
Okay, anyone else? Yes, ma'am?
My knees, it just, hopefully I can stand up before my legs go numb, but
Right, and you
I
all are in
also-
a close quarters too, and we apologize for the accommodations, but obviously I have no control over how tight that is. And so, can everyone hear me clearly?
Yes.
so far,
You're too far?
no, so far.
So far you can? Okay, sounds good. Okay, so you can't sit for a long period of time and you can't predict when you're gonna be in any level of pain that requires you to stand up, sit down, correct?
Right. As long as I can stand up and sit down and that's not a problem, then I,
Counsel, any objection to us relieving her?
I have no objection to her standing up and sitting down.
No objection to you standing up and sitting down?
Objection.
Okay, very good. And you need the same accommodation, ma'am? Okay, I don't think there'll be an objection.
Objection.
I had to mention, this to the other judge. This is controlled by my phone,
Okay,
so if my phone is on, I'm trying to adjust my implant.
okay, sounds good. So you're not having an issue right now though, are you? Okay, no worries. We understand that. Any other medical issues? Everyone can hear me clearly? Okay, and if you can't, just let us know. This is a criminal case. The paper used to charge a defendant with a crime is called a complaint. The complaint in this case charges the defendant, Katina Michelle Lee Newton, with the crime of assault and battery and reads as follows. On or about April 13, 2023, at the area of 1140 Kaywood Street, City of Lansing, Ingham County, State of Michigan, the defendant did allegedly, contrary to law, commit the act in count 1 of assault or assault and battery. She did allegedly make an assault or assault and battery upon the following person, that being a Karen Lockwood, contrary to Michigan Compiled Law 750.811. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal trial so that the defendant and jury can hear the charges. You must not think it is evidence of her guilt or that she must be guilty because she has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. We will now proceed with Voir. Mr. Cartwright.
Thank you, Your Honor. As the judge said before, my name is Dale Coulter, and I'm representing the county and the state of Michigan in this case. So I'm going to ask you a few questions. I just ask you to be honest. I'm not trying to pry too deeply into your backgrounds, but we want to ensure that everyone here has a fair jury for the trial. So just by a show of hands, how many people on the jury have ever been convicted of a crime? Go into that a little bit, and I'm not trying to bear.
Yeah, no, you're good. I've gotten DUIs, MIPs, I was convicted for home invasion.
Okay. Think any of that, any of those convictions would make you have any type of bias against the prosecutor in this case?
No.
Think it could be fair and impartial?
Yes.
Think you could bring back a guilty verdict if you felt the evidence?
Yeah.
Anyone here, besides this gentleman, ever been convicted?
I had a DUI.
You had a DUI?
Yeah.
And that's, if you say her juror number when she responds, he or she.
Number 5.
So, is there anything about that conviction, you feel you were treated fairly by the prosecution in that case? I sense some hesitancy.
Yeah, a little bit, yeah. I'm trying to remember. It was a long time ago, but I wasn't very happy about the whole thing. I mean, obviously, but yeah, I felt like it was a little hard.
Okay. Do you feel that you could be fair and impartial in this case based on your past experience?
Yes.
And if you thought that the evidence warranted it, you could come back with a conviction in this case?
Yes.
Anyone here have any family members that have ever been convicted of? Ma'am.
My brother is a felon. He's done a lot of stuff.
Do you feel he was treated fairly?
Not always, but sometimes, yes.
This juror number 7.
7, yep, sorry.
Is there anything about that situation or his prior situations that you would hold against the prosecution in this case?
No.
If you would hold this to a higher burden based on the fact that you have a family member who was convicted, that he was treated fairly in some cases? And does anyone here on the jury, does anyone here know anyone who's been a victim of assault and battery? So I'll start with juror number 1. Can you explain that a little bit? That was who they were.
I was a victim of domestic assault.
Okay. Do you feel
Juror
you
number
were treated fairly by the system?
Absolutely not.
Is there anything about that feeling that you have which would lead you not to convict in this case, but the evidence warranted it?
Depends on what evidence was presented.
So if you felt that adequate evidence was presented to you, you had a reasonable doubt, would you do a conviction in this case?
I would hope so.
And sir,
Number 3, yeah, I was a little boy and I witnessed my mother being assaulted by a man. My
okay.
sister and I was just a kid. Yeah.
Is there anything about that experience that would make it hard for you to sit on this jury today?
Say no.
Could you return a verdict of guilty if you felt that the evidence sustained that? And subsequently, answer number 5.
Right. It was my ex from years and years ago. It was me.
You feel he was treated fairly by the system?
We never went to court.
Is there anything about, did you witness that?
Well, it happened to me.
Is there anything about that that would make it hard for you to sit as a juror in this case?
No.
You think you could return with a verdict of guilty without the evidence support?
Yes, I could.
And number 7.
My dad was highly abusive to my mom and us kids growing up. So.
Is there anything about that situation that could make it difficult for you to sit on this jury today?
I don't think so. I mean, just because I don't know what's going on. But
Again, you could return. Yeah, sustain that.
Thank you, Mr. Coombs.
Thank you, Your Honor. Afternoon, folks. Who's excited for round 2? No? I understand. Try to get you out here as soon as possible, okay? To that point, I think, just want to echo the judge's sentiment. I think we can get this thing done within a couple of hours. So that's everyone's goal of your time is go home at a reasonable time. Certain seat number 2. Did I read the questionnaire right? Are you you're a homeowner?
Yes,
All right. How long have you owned your home?
3 years.
3 years. You have any kids?
Yes.
2 kids?
Yep.
And do they live with you at the home you own? Do you have any pets?
Yes.
Spouse or partner that you live with?
No.
No? Okay, so you, kids, the
Dog, yeah.
the dog, okay, good answer.
Bias.
How do you, and I assume, without getting into any specifics, of course, I assume your home is somewhere here in the city of Lansing?
Yeah.
Are you like a lawn guy?
A lot, no.
Okay, do you like the projects around the house?
Yeah, I'm always working on those.
Okay. What does it mean to you to have your own place?
It's the first house I've owned, so it kind of means a lot to me. But, you know, at the same time, it's kind of a dump in the middle of the ghetto, so trying to get out of it.
Diamond in the rough?
Huh?
Diamond in the rough? Or?
Yeah, well, I bought it for very cheap. I put more money into it than I paid for it.
Yeah. And so, you know, first home, you got kids, you got a dog. How would you feel if someone tried to barge into your home?
Oh, yeah, I'd not be happy. First, it'd be make sure my kids are safe.
How would you do that?
It depends on what the scenario is for somebody coming in. If there's an altercation beforehand, we went inside because of it, or, I mean, I've been in a couple scenarios and things. It depends. I'm also a gun owner. I have a CPL. But I believe that that's used only, you know, if your life is in danger and threatened, you know. I know.
So I guess to that point, there are different levels of force.
Yeah.
Levels of
First, if you
de-escalation.
Yeah, lock the doors, try and keep them out, make sure my kids got somewhere safe, have them call authorities, you know. Go from there. If it gets worse than that, then whatever it takes to prevent. And I know there's a difference between if they're trying to harm me or my kids, or if they're just trying to take my stuff, like, whatever, I don't have anything that's worth much anyways.
On the flip side, and I'm sorry to pry about this a little bit, but I heard you say that you were also involved in a home invasion case on the other.
Yes, yep.
To the extent you're comfortable, can you tell us about that a little bit?
Yeah, I was like 18 or 19. It all happened on MSU's campus. The girl that I had recently split up with, there's talk that this guy was drugging girls, doing stuff to him. I was intoxicated, angry. I went there to confront him. He went in his house. I followed him. Home invasion.
Well, I know you have a CPL now, so that must be kind of
Yep,
behind you.
Yep, it all got waived. I did my probation and all that stuff. Something that never should have happened, but stuff happens.
Error in judgment then.
Yes.
All right, I appreciate your honesty.
No, you're good.
And then certain seat number 6, I think you're also a homeowner, is that right?
Yeah.
All right, and again, no specifics, but generally speaking, is that here in the city of Lansing?
Yeah.
You got a spouse or partner you live with?
No, just my siblings.
Siblings, all right. Ooh, this is a tricky question. How do you feel about that?
What I told my siblings?
Yes.
Love them to death.
Okay. I can now live with my
Problems
sister.
are all.
So, would you feel if someone unwelcome was trying to come into your home?
How would I feel about it?
Yeah.
I mean, it's me and 3 other dudes in the house, my brother, so I think the problem's gonna be for them, not for us.
So it sounds like you might, if pressed in, if the circumstances warranted it, you might take matters into your own hands. And then, sir, I also see you're a community advocate, is that right?
Yeah.
Okay, tell us about that.
So essentially, I got hired by Advent House Ministries, which is a nonprofit, basically a church. And they help out with all kinds of aspects as far as this community goes. So those who need help with substance abuse, housing, family services, that nature. But essentially, as a community advocate, I'm stationed at the CAT station. So for anybody who needs services, who happens to be at the CAT station, we help them out with bus passes, advocacy for them. If they got to call somebody, we go out of our way to sort of have those hard conversations that they need to have with other professionals.
Well, thank you for doing that. I assume maybe some of your, I guess, do you have patient load or client load or?
In a sense, I used to do case work, but the advocacy portion is you're gonna have anybody come knocking at your door, so they may not ever have had services before versus someone who's like a client who you see often. So no, I don't have a client.
Well, so I guess that some of the people that you have worked with in the past, their issues kind of lead them to have some issues with the criminal justice system.
Yeah, pretty often that's what it is.
Right, and I guess you're maybe a degree removed, but having worked with those folks, is there anything about their experiences?
Yeah, I would say often enough they're not heard, they're not believed, and so they're not included in a lot of things. And I make it a priority from the way I work anyways to believe them, hear them, take their side of the story completely, and bring it up to those who are not hearing it as well, because I feel like they're just underrepresented. So,
thank you. Number one, I think I heard you say you were a victim of domestic assault.
Yes.
I'm very sorry to hear that.
Don't be. It changed things,
For the better.
not so much.
Are you comfortable sharing anything about it?
Nope, I cried at the other courthouse, or the courtroom. I moved away from that.
Okay. And with that, I don't want to pry into any specifics about what happened to you. I heard you say you weren't treated fairly by the system. Can we talk about that? Are you comfortable talking about that? I'm not comfortable, but
He got a slap on the wrist.
Okay.
Everyone was called to this courtroom. Witnesses weren't even called. The story wasn't even told. He got called up. He didn't get probation. He didn't have to pay any fines. He got nothing. And we were left to just deal with it.
and you wish your story had been told.
I wish more had been done to get him off the street, because he continued to hurt more people.
Thank you for sharing again. Appreciate it. In seat number 5, I think you were also a victim yourself. Is that right?
Yeah.
I'm sorry to hear that. Are you okay sharing a little bit about that?
An ex-boyfriend.
Okay.
Yeah.
All right. And you said it never went to court.
No.
Was that I guess was that by choice? Meaning was there ever police involvement in those?
Yeah.
Okay. You called the police?
Yeah.
And did they just, was there no follow-up, or did you not want the?
I didn't want to go through with
I see.
anything, but they still went after him.
Okay.
He hired an attorney and
Eventually dismissed?
dismissed.
Okay. All right. I guess on that side of things, did you feel like you were, I don't know, being dragged through something?
No,
Okay.
no. Mm-mm.
Okay.
I was glad it was just all done with.
Now, obviously, we're here at trial. We have someone complaining of a crime who maybe sees things a little bit differently. The fact that she's wanting to take the witness stand and testify against my client, does that, I guess, what do you think about that?
I don't, one way or another, that's not, I don't think it'll affect me. What are you trying to ask me again?
Well, I guess just, so you wanted things to be done with, you didn't want to go through with the court proceedings and all that.
Yeah.
You just want it wrapped up. And we have somebody here who's going to be testifying. I guess, does the fact that she's
No,
testifying?
not at all. That's her choice. It's her life. Yeah.
Okay. Well, does it, I guess, in your mind, does it make the story any more or less believable because she's willing to?
No, that was my personal choice, something that was best for me. So, no, not at all.
Okay. Thank you. So in seat number 3, you talked about having witnessed your own mother being assaulted by a man when you were a child.
That's correct.
And I'm sorry you had to witness that. How old were you?
Probably 4 or 5.
4 or 5. And it was a grown man who was,
Yes.
right? And so, I mean, you're pretty young. This sounds like it's core memory kind of burned in there.
It definitely defined, I mean, it just marked my entire life. I mean, I'm not, I went through a trauma. I'm not traumatized, but it definitely marked the way I'm actually are today towards women,
Yeah.
especially.
You wish you could have done something.
Well, I don't know. I was a child.
Right.
So
I obviously you couldn't. Right.
Yeah.
You're a small boy at the time, and this is a grown man.
Right.
In the moment, it's the best you can remember. Do you remember thinking you wish you could have done something?
I actually did, which one wish I was out of the way.
Yeah. So even at 4 or 5 years old, you wanted to rush to somebody's defense.
Correct.
Seat number 4. I don't think we've heard much from you yet. So let's break the ice. You're a nurse. Did I read that right?
Yes.
All right. Is that a local hospital here? Okay. One just down Michigan or somewhere? Okay. All right. And what do you, are you like in the ER?
Labor and delivery.
Okay. That's gotta be challenging, exciting, all of the above.
It's all of the above, yeah.
I know my sister-in-law who does the same thing down in Jackson, has some stories. Probably in labor and delivery, you don't have a whole lot of contact with law enforcement, I guess, unless there's concerns about
Yeah, unless.
drug
there's,
use
like,
or something like
concerns, yeah, but otherwise, no.
I guess anything from your job duties that make you more inclined to believe a police officer or someone complaining of a crime or something?
No, we tend to try to be very unbiased in our role. We have a variety of patients with a variety of histories, so we just try to take care of the patient in that moment, but biases.
Okay, and so each patient requires a different plan of care?
Yeah.
Okay. So you have to kind of listen to everything when a patient's telling things and look at their history. You think you could do the same thing in this courtroom?
Yes.
Listen to all of the facts?
Yes.
All of the witnesses?
Yes.
And then make a decision from there? All right, thank you. Ma'am, in seat number 7, I don't think we've spoken yet.
For a minute, yeah.
Okay, so I know your brother's been in some trouble. Sometimes he gets what he deserves, sometimes maybe it's a little overboard. I guess where has prosecutions taken place here in Hingham County or?
Ratchet.
Ratchet,
Yep.
okay. So nothing, I guess, for or against Lansing Police or Hingham County Prosecutor's Office as a result of that? No? Okay. I guess, were there ever any cases where you felt like he had a legitimate defense and wasn't heard?
That what was it?
He had a legitimate defense and
Yes.
wasn't heard?
Yeah.
Okay. And, so I guess are those the types of cases, or that the type of case you're talking about where he
Yeah.
wasn't treated fairly? Okay, I'm wrapping up, promise. Just one last topic I want to hit on. Beyond a reasonable doubt. Does somebody have thoughts they want to volunteer about that phrase?
Very in-depthly.
Okay, all right. What's your understanding?
Okay, beyond a reasonable doubt is more yays than nays,
Yeah,
you know, the
Yeah.
balance.
yeah,
Is the evidence more?
something more than 50-50.
Yes.
Yeah. In the judgment.
But it could be either way, could be like guilty or not guilty or innocent. It just depends on that balance of the scales.
Okay. And the judge will, of course, tell you what the law really is. There's no percentage we can put on it. Does everybody understand that? All right. Now, does anyone believe that my client or I would have to prove anything here? I'm seeing a lot of,
Your client is the defendant,
that's right.
so it's his job to prove otherwise than innocent.
Is everybody comfortable with that?
It looks like my old principal.
I do. Oh, he does.
He looks like a cop from Gratiot County, actually. I thought it was him. I was like, that's
Anything
That
about
may swim.
him looking like your principal? Is that a problem?
He
Or?
was a really nice principal.
Okay.
I'm gonna be biased now. That's like my friend.
All right.
And he's biased against cats.
I am not on trial.
He could be biased, he's not a jury.
Okay, and then last question about Roosevelt. I don't know what was going on down the hall, but this is a case where I think you're going to hear a bit about self-defense. Was that an issue down the hall? Okay. Well, that's actually, that's a good point. Juror number 7, thank you. So does anyone have a problem with the idea that the prosecutor has to prove beyond a reasonable doubt that my client did not act in self-defense?
Are you asking a
Juror
question?
number 1,
Are you
you
asking
do not have a problem with that, right? I mean, that's a question,
The
yes.
question is, do any of us have a problem with allowing him to try to prove that she didn't do what his son?
Well, so it's kind of tricky because, yes, so not just, right, spoiler alert, I think Mr. Cartwright is gonna prove that my client threw a punch and the punch made contact. One of the things he has to prove is that it wasn't in self-defense. Does anyone have a problem with that?
No.
See a lot of people shaking their heads. Thank you, folks.
Are you finished?
Yes, sir.
Okay. Any challenges for cause?
None for cause from people here.
Not for cause.
Preemptory.
Yes, Your Honor, people would thank and excuse juror.
Jury number 2.
Alrighty.
Do I have to hang out or can I?
That's not you.
Oh, Bobby.
Sorry.
It's the other two.
Do I have to-
Sorry.
Do I hang out?
I was 2 last time,
Oh, yeah,
wasn't I?
sorry. Okay.
Yeah, he's all set to go at this point. Thank you, sir. Okay, any preemptory?
Not at this time.
Okay, I'm gonna place number 2. Michael Anthony Torres. Question.
So number 2. If I were to say to you, raise common sense, what is that?
Common sense.
Yeah. Is that based in rationality? Now, you understand that I have the burden of proof here, right? Yes. You want to hold. When I say the term, so that's what it means.
Somebody was trying to cause bodily harm to an individual.
Think of an example of that.
Let's say I'm in the grocery store and for some reason, somebody tried to come at me and try to do bodily harm to myself, and I maybe defended myself physically with a punch or something.
Now, you think you, that's an interesting point. If you're not, you think you would use self-defense for yourself if you're not here?
Somebody was coming to do bodily harm to me, and I felt if I was gonna be harmed, yes, I would.
Or if you didn't think?
So somebody was coming to do harm to me, but I wouldn't
They
think I
weren't
was gonna
coming
be.
to harm. You didn't think that was.
Oh, if nobody was coming to do harm to me, I wouldn't have any defense.
Now, do you think when a person uses self-defense that they can use the old phrase, bring a knife to a gunfight, bring a gun to a knife fight? You understand what that means? Explain that to me a little bit.
Well, I've heard the phrase, bring a knife to a gunfight. I've never heard bring a gun to a gunfight.
Well, turn it around a little bit. What is it?
I guess if I flipped it, I mean, I would, the only way I know how to put it was put it into an example, maybe if you're gonna fight somebody and you end up bringing a weapon or something, that's what it means to me.
Well, let's. How about bringing a weapon to a fist fight? What does that mean?
Bring that with fist fight with somebody brought a weapon.
All right. You heard all the questions that were asked earlier. You had any criminal conviction in your background? Any family members that had that?
Oh, yes, my brother's a felon.
And you feel he was treated fairly?
Yes, he was treated.
And there's nothing about that you hold against the prosecutor. Have you had any interaction with police officers?
Oh, yes, I have.
Have you had any negative interactions?
Oh, yes, I have.
And is there anything about that which might cause you to not believe it's police officers right off the bat?
No.
Anything about that aspect of the hold against the prosecution?
No.
It's here, your property, though.
Yes.
And it's in the city of Lansing. Correct. How long have you been at your home?
6 years now.
And if I were to say the term to you, self-help eviction, what does that mean to you?
I don't.
Okay. All The word eviction, what does that mean?
Somebody getting kicked out of a place that they were currently residing in.
You think a person has the right to get someone out of their house, out legal process?
Counsel.
Afternoon, sir. Picking up where we left off, what if the tenant agreed to move out? Does that change things in your mind?
Yes, if the tenant agreed to move out, they should go on there.
Take backsies, taking backsies? It's a legal term. They can't change their mind once they.
No, I would say if you agree to leave, you leave.
And then, is the phrase bringing a fist to a fist fight?
No more questions?
No, thank you.
Okay. Challenges for cause?
None from the people. No.
Of course, Your Honor.
Any preemptory?
Takings.
Number 5, thank you. Yep. For your willingness to serve. Okay, we're gonna put Alicia Tom in seat number 5.
Just so we have clear record, no parentheses.
Oh, yeah, I was gonna call it that, ask you right
Oh, I'm
after,
sorry.
no worries. Okay, none for you either, you're waiving?
Yes.
Okay. Okay, you can proceed to question.
Ma'am, you heard the questions that were asked earlier by both the defense and the prosecution. Do you have any response to any of those questions?
No.
The question was asked earlier. He had agreed to move out of the house. I think the answer was they should stick to the agreement to move out. Not moved out yet. Person has a right to implement a legal process.
If they had agreed to move out within a specified period of time, they should be given allowed that specified period of time.
They need to put that person out without going to court.
No.
Yes. Can you speak up for the record?
Sorry about that. Do you believe that person doesn't leave, that you have a right to strike that person?
No, you should go through legal processes.
Mr. Coates?
Good afternoon, ma'am. A couple questions for you. I see that you're a call center representative, is that right?
Yes.
All right, and what does that entail? What do day-to-day entail?
Basically, talking to the general public, informing them about the company's product, what their options are, things like that.
And what's the company?
It's
I'm sorry?
Sealing.
Sealing, what do they do?
That's dealing in reverse mortgages.
Okay. Now, is it all outgoing calls or incoming inbound?
Inbound.
Okay. Are you like the complaints department?
It can be.
Okay. How's that dealing with those complaints?
It's something new every day.
Yeah.
I'll say that. It's a variety.
Do you have like a CRM or a phone system where you can see prior contacts with a particular customer?
Yes, we have a notation for previous calls, so we can get our system.
Okay, and then are there, I guess, some callers who are maybe frequent flyers who call in more often than others?
Yes,
Okay. Are they, in your experience, do they tend to be a little bit more problematic?
not necessarily.
Okay. They may have legitimate complaints.
They may have complaints, we deal with a lot of elderly people, so they just forget that they called the day before and asked the exact same question.
Yeah. I'm sure that's tough in its own way.
It's a challenge.
Yeah. Okay, that is all I have for you. Thank you.
Challenges for cause.
None from the,
Not for cause, Your Honor.
Any preemptory?
we have none.
Your Honor, I would like to thank and excuse juror number 5.
Thank you. You may be excused. Okay. Seat number 5. We want to put Kimberly and Walker.
Number 5, a lot of questions have already been asked. Do you have any immediate answers to any of those questions? I notice it indicates in your file that you are a renter, home renter. Is that correct?
Correct.
You have a landlord, obviously.
Mhm.
Is that a yes? Is that a yes?
Oh, yes, I'm sorry.
Do you believe your landlord has the right to just remove you from the property without legal process?
No.
If you didn't leave, you believe your landlord has the right to strike you?
No.
In an argument, do you believe physical violence is ever justified?
No.
Mr. Coots?
Ma'am, do you rent an apartment, a home?
An apartment.
An apartment, is it in a complex or like a duplex?
No, there's 42 units in the building. I'm a lifelong renter.
Okay. Does your landlord live in your apartment too?
No.
Do you think if you agreed to move out of your apartment and then change your mind, you could barge your way into your landlord's home?
No.
Now, you mentioned that, I guess, violence is never the answer or something to that extent, is that right?
Yeah. You can say
Yeah. Do you think people have a right to defend themselves?
Yeah.
Anywhere? If they're in danger anywhere, they can defend themselves anywhere?
if somebody's going to hurt me, I have the right to stop them.
Do you think that there's like something special about being in your own home where that, where self-defense is even more?
I guess I would put extra effort to keeping someone out of my home.
Okay, thank you.
Challenges for cause?
None for cause?
None for cause, Your Honor.
Preemptory. Well, I think we might be out of preemptories. Not everyone's out of preemptories, actually. You waived twice and you said 5.
Well, Your Honor, it was not at that time.
I'm sorry?
When I
You waived twice. You only get 3.
Okay.
When you waive it, it waives it. And you say none. Okay. So are we satisfied with this jury?
You're satisfied.
I have no challenges, Your Honor.
Okay, very good. Ladies and gentlemen, you will serve as our jury for today. Those of you all who are waiting to get into the jury seat, we thank you for your patience today and your service thus far and your willingness to be here. If you want to follow our representative here, we'll make sure you get what you need so that you can be on your way. The remaining of you all, I'm going to go over some instructions, and then I need to take a recess to let you all go to Treasury to receive your payments because they close at 4.
Is this considered a whole day? Yeah.
I'm sorry,
Is this considered a half day or whole day?
you were here all day.
We get to use the bathroom in between.
Do you need to use the restroom now?
Yes.
Okay, well then we'll do the instructions after the fact. Just remember that you all are selected to be the jury. You can't make any contact or communication with anyone in the hallways because you don't know who may be connected to this case, okay? And so you can get some water, use the restrooms, and then when that gentleman comes back, I'll make sure he shows you where to go to Treasury. We're gonna do all that now and then come back here hopefully by 10 minutes after. All rise for the jury. You all can file in. I'm actually gonna have juror number 1 sit at the end. And then juror number 5, you're actually going to be thanked and excused, so you can gather your thanks. Juror number 5, yes.
Right.
Thank you for your service.
You want me where she was?
No, you can just file in. She's still gonna be number 1. I'm just gonna move her to the end so that she's not trying to file out, and she has more space if she needs to stand up.
Okay. Got it.
Thank you. You can be seated. We will turn our attention back to the screen for further instructions. Ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. If you could stand, raise your right hand. Do each of you solemnly swear or affirm in this action now before the court that you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court? If you do, say I do.
I do.
Thank you. You can have a seat. You will get a written copy of my instructions, but it will be at the time that I release you to deliberate. Since no one can predict the course of the trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for you to use during your deliberations. Now I will explain some of the legal principles that you will need to know and the procedure that we will follow in this trial. The defendant is charged in count 1 with assault and battery. To prove this charge, the prosecutor must prove beyond a reasonable doubt the following elements. First, the defendant committed a battery upon a Karen Lockwood. A battery is a forceful or offensive touching of the person or something closely connected to the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Karen Lockwood's will. It does not matter whether the touching caused an injury. Second, that the defendant intended either to commit a battery upon Karen Lockwood or to make Karen Lockwood reasonably fear an immediate battery. The defendant is charged in count 1 with the crime of assault and battery. And to prove this, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant either attempted to commit a battery on Karen Lockwood or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful, violent, or offensive touching of the person of another or something connected with the person. Second, the defendant intended to either commit a battery upon Karen Lockwood or to make Karen Lockwood reasonably fear an immediate battery. An assault cannot happen by mistake. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought she had the ability. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about April 13, 2013 within the city of Lansing, Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. The trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witness. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in the trial is to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide the case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in the case is final. Part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin, or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to make an honest effort to tell the truth? Or does the witness seem to evade the questions and argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any personal or special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some questions of the witnesses myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would to be asked about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, you do not ask it yourself. You would raise your hand, write the question down, and pass it to my court officer. He will give it to me. Do not show any of the other jurors your questions. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. Can you test that for me? That's fine. Thank you. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to those interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave. Report the incident to my staff as soon as you return to the court. When the trial is over, these restrictions no longer apply, and when the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them, because news reporters do not have to meet these standards. They could give you incorrect or misleading information that might unfairly favor one side. So, to be fair to both sides, you must follow this instruction. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any knowledge or personal knowledge you have of the scene. You must not share any information about this case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to court staff. You may not take note, you may take notes, You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see, we release one juror so that we can exclude that instruction. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. And then following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken together, they are the law you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some other of our biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may be unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. You can make your opening statement.
Your Honor. So, ladies and gentlemen, sometime back in mid-November of 2022, two individuals, Ms. Karen Lockwood and Ms. Katina Newton, came to an agreement that Ms. Lockwood, who was living at that time in Alabama, would come to Michigan and move in with Ms. Newton, and they would share the rent. That did happen. Ms. Lockwood did come to Michigan. She did move in with Ms. Newton. Sometime around March of this year, things started to go a little sour, as they do when young people get together and have these arrangements with joint tenancy in an apartment. At some point, Ms. Newton requested of Ms. Lockwood that she move out of the home, and she gave her 30 days to leave. At that point, Ms. Lockwood indicated she would try to be out within 30 days. Things got worse, as they probably would in this situation, because they kept living together. At some point, around April 12th, Lockwood indicated she was going to leave for the evening, and she left and checked herself into a hotel. She then found out that she had other legal rights. She was having a hard time finding another place to stay and being able to afford it. Came back to that property on the evening of April 13th. That property was located at 1140 Kerwood Street. That was in the city of Lansing in Ingham County, Michigan. When she came up to the door, Miss Newton was at the door and told her she was not allowed in the house. Miss Lockwood entered the house anyway at that point. Following which, Miss Newton grabbed her by the hair, pulled her down, turned her around, took her fist and hit her in the face with her fist, damaging her nose. Following this, Miss Lockwood called the local police department, who did respond. Miss Newton left the property. When the officers got there, they took a statement from Miss Lockwood. Miss Lockwood indicated she had been assaulted by Miss Newton by having her hair pulled and by being punched in the face. Officers then did make contact with Miss Newton and did take a statement from her. The officer that will appear today is Zachary Johnson. He's the officer who took this statement. He also took photos of what happened. Mr. Johnson, Officer Johnson, is going to testify that the statements he took exactly mirrored each other. And that's why we're here today. We're here because we're going to prove that on that night of April the 13th, Miss Newton assaulted Miss Lockwood, pulled her by the hair, turned her around, took her fist, and hit her in the face. And we're also going to establish that she did not do this in self-defense.
Mr. Kincaid, if you want to make it open statement at this time.
Yes, thank you, Your Honor. The early morning hours of April 14th, 2023, my client, Katina Newton, found herself somewhere unexpected, the back of a cop car. Not only was this a new experience for her, but it was an undeserved one. For several months, Katina had been renting out a bedroom from her home that she owns to an old friend, Karen Lockwood. Katina did this because Karen needed a place to go, and so they worked out an arrangement, a bedroom of Katina's home for rent money. Katina held up her end of the bargain, providing a bedroom. Karen did not, though. The arrangement began to fall apart almost as soon as it started. Karen was late on rent payments throughout the course of the tenancy, and for the last couple of months didn't make any payments at all. So Katina asked her to move out. Now, to be clear, Katina did not formally evict Karen. She did not serve a 7-day notice or a 30-day notice to quit. She did not bring Karen to this court or one of the 3 other courtrooms in this building to be formally evicted. Katina and Karen did what we hope most people do when they have a disagreement, which is figure it out outside of court. So on April 11th, 2023, 2 days before the incident that issued here, Karen moved out of Katina's home. Karen, I believe, stayed with her boyfriend in the greater Detroit area, Metro Detroit area, for a few days. At some point, didn't like what the rental rates were, changed her mind, came back to Lansing, and at 11 p.m. showed up on Katina's doorstep. And I think she gave notice via text message at about 10:54 p.m. saying, I'm moving back in. A few minutes later, she's at the doorstep. And Karen pushes her way into Katina's home. And in the process, puts her hands on Katina And then you know what Katina did? She did exactly what I would have done in her situation. She did what most of you probably would have done in her situation. She did what she should have done in the situation. She punched Karen in the face. The prosecutor is going to prove that part. The prosecutor can't prove that this wasn't in self-defense because it was self-defense. Not only was it in self-defense, but it was in self-defense in her home at 11 p.m. And then, now that Karen is there in the home, and I actually want to take a step back. Katina threw one punch, just one. And then the situation ended. Katina left her own home at that point. Yes, Karen called 911, but you know who else called 911? Katina, because Katina also wanted this sorted out. Officer Zachary Johnson showed up on the scene, got Karen's side of the story. He also spoke to Jaquille Stevenson, which is Katina's boyfriend, who goes by Jack. And then he met Katina in the parking lot of the Famous Taco, got her side of the story. And Karen had a cut on her nose, Katina didn't. Katina got arrested. So there Katina was, being arrested for defending herself in her own home. And here Katina sits on trial for a crime for defending herself in her own home. Now, Karen believes, I think legitimately believes, she had a right to the home.
I'm going to object to, I don't think he knows my client believes.
Not his client, but I can rephrase, Your Honor.
Okay.
Now, it's a reasonable inference that Karen was reasonable to believe that she had a right to the home. I think she's going to testify that she believed that. I disagree. Ultimately, the judge will tell you what the law really is on this issue. At the end of the day, though, I don't actually think it matters that much. And here's why. What matters is what Katina believed. Right? Put yourself in Katina's slippers. She thought she had an agreement with Karen that Karen was going to get out. Karen took her stuff and left for 2 days. Katina's mindset, Karen is no longer a tenant in her home, and then Karen shows up, barges her way in, puts her hands on Katina. You put yourself in Katina's slippers, I think you might be a little bit scared too. So Katina acted in self-defense. It's almost 4 o'clock and we're doing opening arguments, but I do expect this will be a quick trial, 2 witnesses aside, not a whole lot of facts here. This is a remarkably simple case. The prosecutor is going to prove that my client threw a single punch and landed that punch. He's going to prove that beyond a reasonable doubt. The problem with the prosecutor's case is that the evidence will prove beyond a shadow of a doubt, and my client also did this in self-defense. Thank you.
You can call your first witness.
I'm going to call Officer Johnson. Hang on, I think we'll call Officer Zach Johnson, the Lansing Police Department.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Thank you. Can I have a seat, officer? State your first and last name and spell both of them.
Zachary Johnson, ZACHARY JOHNSON.
You can proceed.
Thank you. Officer Johnson, where are you employed?
Lansing Police Department,
And how long have you been employed there?
over 6 years.
And what is your principal duties right now?
Night shift road patrol.
Okay. Now, I want to take your attention back to April the 13th of 2023. At that time, did you respond to 1140 Kerwood Street, Lansing, Michigan, 48915?
I did.
And what was the reason for your response to that location?
It was a report of an assault that had just occurred.
Okay, and that was, how long did it take you to get to that location from the time you received the report?
I'm not sure. It's hard to say because it changed and it was busy.
Okay,
But it was around 11 o'clock that night.
all right, so you responded around 11 o'clock that night. Now, when you responded to that location, and that 1140 Kerwood Street is in the city of Lansing, is that correct?
Yes.
King County, Michigan. Were you in a fully marked squad car that day?
Yes, I
And
was.
were you dressed in a police uniform that day?
Yes,
And when you responded to that location, did you have contact with anyone?
I did.
And who was it that you had contact with that day?
It was a victim. I can't recall her name at the correct time, but it was a victim and said that she had been assaulted by her roommate.
So if I were to present you with your report, would that adequately
It would.
refresh your recollection? You know, permission to approach.
You may.
When you're done. And who was it that you had contact with?
The victim was Karen Lockwood.
Okay, and when you got to the location, was she in the house or outside of the house?
She was at the door. She
Okay.
had the door.
And what was the first thing you noticed about Ms. Lockwood?
She had a cut across the bridge of her nose.
Okay. And did she indicate to you how she received that cut?
Yeah, she said that she had a dispute with the defendant over housing. Said that there was some sort of civil dispute, that she'd been living there for some time. But they were talked about having her move out and they were working on a project to get her out of there. That fell through. She came back to that residence tonight.
She indicate to you how that assault occurred or how she was assaulted?
So she had her back.
Okay. If there's an objection, did you want to respond?
Yeah, it's just for medical purposes, Your Honor, why the officer did what he did. I believe that the fire department was called.
So it's not being offered for the truth of the matter asserted. Objection is overruled. You can answer.
She said she responded back to the house after her plans fell through to go back to the place where she was living at the Kaywood Street address. And she was not let in by the defendant. The defendant told her that she needed to come back with a lawyer. So she, knowing she was living there, pushed past the defendant to go back to her room. And then she was grabbed by the hair and punched in the face by the defendant.
At any point, did she indicate to you that she had struck the defendant?
No, she said she just tried to get back into the house to go to her room.
What was her demeanor? How was she?
She was upset. She was, it seemed like very frustrated due to the circumstances of the situation. But she was just kind of distraught, like someone who had she was pissed off, for lack of a better term.
Did you have contact with anybody else in the house that day?
Yeah, it was a male subject who was sitting on the couch. I believe it was the defendant's boyfriend at the time.
Did he indicate to you whether he had observed this assault or not?
He was kind of having it on about it. It seemed like he didn't really want to say much to me about what had actually occurred, but that a dispute did occur and that they had kind of an ongoing issue with an eviction of the victim.
Now, at that time, when you were at that scene, did you take any pictures of the injuries that were suffered by Ms. Lockwood?
I did. I took pictures of kind of an overall upper body photo and then a closer up one of her face.
Your Honor, I have what is people's proposed exhibit 1. I'm going to show that to you. That's if I could approach the witness, Your Honor.
You may.
I have what is people's proposed exhibit 1. Is that in fact a picture of what you took that day? Is that a picture?
Yes.
And is that an accurate reflection of how Ms. Lockwood appeared to you that night when you had contact with her?
Yes.
Your Honor, at this time, I would need to have that exhibit entered into evidence.
Any objection to people exhibit 1?
No, Your Honor.
People's 1 is submitted.
And just to, I know we want to speed things up a little bit, Your Honor, I have what is people's exhibit 2 and 3. I'll show those. And if I can approach.
You may.
I'll handing you what is people's proposed exhibit 2 and 3. Are those also photographs that you took that evening?
Yes.
And do they accurately represent how you observed Ms. Lockwood that night?
They do.
Your Honor, I would also move to have those.
The objection to 2 and 3.
No, Your Honor.
Your Honor, I would
Admitted.
move to have those published to the jury.
You may.
Now, at some point that evening, did you have contact with Miss Newton?
Yes.
And where did you have contact with her at?
It was probably 5 or 6 blocks away, back, near the old famous taco on the west side there, right on Saginaw.
Okay, so she was not physically at the 1140 Kerwood Street.
Correct.
And you responded to that area and you had contact with her, is that correct?
I did, yes.
Now, when you had contact with her that night, did you notice any injuries on her at all?
Not that I recall.
Did she complain of any injuries?
No.
If you had observed injuries, would you have memorialized that in photographs like you did with Miss Lockwood?
Yes.
And on that evening, when you were having discussions with Miss Newton, did she tell you what had happened that night? Did she tell you she had assaulted the victim that night?
Objection to the characterization, I think assaulted. That's for a legal conclusion.
Did you want to respond to the objection?
I think it's these are statements against penal interest. I can rephrase the question so that it's not an assault, so that I'm not mentioning that it's assault.
Yeah, I think punched would be fine.
Okay, I'll allow you to rephrase the question.
Did she indicate she had punched the victim that night?
Yes, she did. Her statement mirrored the statement that I had earlier taken.
So when you say mirrored, how it was exactly
It
the
was
same?
very similar, yeah. She had talked to me about an ongoing civil dispute with an eviction with the victim that she had, I asked her if she had done any formal eviction process. She said she didn't, which gave the victim standing in the residence. And then she said that, that she kind of lost her temper when she came in the house and he grabbed her by the hair and punched her.
After you took this statement, did you allow Miss Lockwood to stay at the property that night?
I did.
Okay. You had made a conclusion that she had legal standing to be in the residence.
Correct.
Now, in her statement to you, did Miss Newton ever indicate to you that she had punched Miss Lockwood in the face in self-defense?
No, I mean, she was very upset and distraught. It almost seemed like she was upset that it had gotten that far, but it didn't seem like she like that she had punched her or had gotten punched or anything like that. It was more of like she shoved past her to get inside the house.
So based on the two statements you heard that mirrored each other, what was your conclusion at that time?
Well, I had a victim with injuries and I had someone without, and they were corroborating statements that were the same story. And I made an arrest on it for assault.
So neither neither party claimed there was any, that my client had assault or that the victim had assaulted the defendant here. Is that correct?
Correct.
And just once again, if you had seen injuries to the defendant, you would have memorialized that in photos.
Yes, I would have.
Was Miss Newton apologetic to you that night for what had happened?
Yeah, she was upset. She was crying, and like I said earlier, she's frustrated that it had gotten to the point that it gotten to, and kind of felt like she didn't have options. But I kind of informed her of the process she should have taken with the eviction process and that sort of thing to avoid what had happened that night.
Now, earlier when you had your contact with Miss Lockwood, did she request medical treatment?
She did initially, and then refused once fire department showed up.
But she did initially.
She did initially.
And how long did it take the fire department to respond?
I can't remember. I mean, I would say less than 10 to 15 minutes, and sometimes it varies, but it depends on if they were safe or not.
Now, do you remember how long after this event it was that you had contact with Miss Newton?
It was quite promptly after speaking with the victim, because I think she had contacted her boyfriend, and that's how I figured out where she was, because I was trying to figure out where she was. I think she had texted her, called her boyfriend, and he's like, hey, she's on the phone. She's over at Famous Taco. You can go talk to her right there. She'll wait there for you. So it was pretty quickly after getting the initial statement from the victim.
Did I have no further questions.
Cross-examine.
All right, thank you, Your Honor. Good afternoon, Officer Johnson.
Good afternoon.
Just a handful of questions for you here. I guess I want to start with, as a Lansing police officer, I guess, how long have you been employed there?
Over 6 years.
Over 6 years. I know some law enforcement agencies will kind of like carry out evictions, put people's stuff to the curb. Does Lansing Police Department?
It's handled by the county. It's
Okay.
not handled by the city.
All right. And I guess does the Lansing Police Department get involved with the eviction process at all?
Not typically. Sometimes we've been known to do civil standbys if someone simply like a custody agreement where they have something like that. They want us to stand by to make sure nothing goes wrong. But that's typically, we typically steer away from those. So it's not a typical thing we do.
Okay. And sorry to pry, do you own any rental properties or anything like that? Okay, so you made a determination at some point that Karen had standing to be in the home, is that right?
Correct.
Okay, and so what are you basing this on?
Statements from both the accused and the victim. People say, sometimes standing is not required to be more than a few days staying. And that's kind of how we work with our daily life as cops, because a lot of people come in and say, hey, I let them stay here for a week and now they won't leave. Well, it's hard because there's so many different laws pertaining to that. It's hard for us to make a determination in that moment that, okay, I'm going to grab you out of your home and make you leave. But she had said she had been staying here for a couple months. So that's what I based that information.
So this is based on an LPD policy or practice?
It's kind of like a general practice that, if you've stayed someplace for more than a bit, I don't know the exact state law on it. It's all civil law. I have to keep it criminal. So as a standard practice, if you stayed there for more than a couple days, 3-4 days, we say, hey, we got to evict somebody. That's got a court order that gives us something to work off.
All right. So the when you make the conclusion on the night of April 13th of this year, this is based on LPD practice, not any specialized knowledge in landlord-tenant law that you have?
Correct. I don't have any specialized knowledge on landlord-tenant law.
So going back to your interactions with Karen, you mentioned that she was upset.
Yes.
I think pissed off was a term that you used. And at some point she was crying.
Yes.
All right. Was she crying the whole time or just for a short period?
Just for a short period. I do a pretty good job talking to people, get people calm down and get the full story about what happened. So she kind of eventually calmed down.
She seemed pretty concerned about her rights. Is that right?
Yes.
And you testified that her story is similar to what you received from Katina. Now, in speaking with Karen, what was your understanding of how she got across the threshold into the home?
It seemed like, I mean, I can't remember exactly without looking at my body camera, but it was like she shoved past me, pushed past me, that sort of thing.
And I'm sorry. I'm asking, is that when you were speaking with Karen, the complainant here, not my client?
Right.
Is that something Karen relayed to you? That she pushed past Katina?
Can you rephrase the question? I'm sorry.
So
with the different names.
Yeah.
Maybe
A couple
prefer
K
the
names.
last name or something would be helpful, but.
Okay, the complainant, Karen, did she say something that, I'm gonna move on. You spoke with Jaquille Stevenson.
Yes.
Is that right? And that's my client Katina's boyfriend?
Yes.
Okay. And on direct examination, I think you used the term that he was hemming and hawing.
Yeah.
And what was that in relation to?
When I asked him if anything happened, he seemed reluctant to say what had happened. I'm not sure what that was, but he, sometimes in my training experience, sometimes spouses or partners typically either want to stay away or they don't want to say anything that would put their partner in a bad spot.
So it's your testimony here today that he was not forthcoming with information?
No, I'm not saying that. He just seemed like he did not want to get involved. He didn't give me what seemed like a lot of information for it. He did help me find her, and so he was not withholding that per se, but to the best of my recollection is I don't remember him saying what exactly he saw.
Did you review your body cam before?
I did not.
Okay.
Are you expecting to share?
Yes, I can connect to the HDMI.
If you, it's easier if you just log into Zoom and then you can share screen.
Okay, will it play a video?
Yep,
Okay,
you just
all right.
share screen and share the sound. I'm gonna also make you co-host because that's the only way you can share. Okay.
Officer Johnson, I muting myself. I have your body cam from that night starting at 2 minutes 45 seconds into it. This is not. This is, I guess, for the court's perspective. This is impeachment purposes. This is not direct evidence I'm trying to introduce.
It's not just refreshing the recollection, is that what you're saying?
Well, it's for impeachment.
Oh, impeachment, okay, sounds good.
I'm logging back in.
Oh, you got booted.
I booted myself because I think it was a restart issue. I'm sorry, Your Honor, could I be made a host again?
Oh, sorry. Over to- oh. And just make sure you hit the share sound when you do it. You hit share sound.
I did, Your Honor. Your Honor, could I just, set my laptop in front of the officer and play it sound up?
That's fine.
Okay. All right. So Officer Johnson, I'm starting at 2 minutes 48 seconds now.
I heard, she said that you saw everything? Oh, we're laying down asleep. Okay. But I can hear some commotion, because we're walking up, as well. I don't know, it seemed like she might struck my girlfriend. Okay. So things kind of started off here. What's the background? What's the story? So my girlfriend gave her 30 days to move out. Okay. She agreed to it. She said she had an apartment. So everything lined up. Everything lined up. So she said, Thursday today actually, she said that family was coming to come get her stuff and she was gonna go. Well, she texted my girlfriend and said, well, I don't have to leave. My parents told me to come back home, I can bring my stuff back here and stuff.
I'll go ahead and pause here at 3 minutes 53 seconds. So we let that play for a little over a minute. Is that right, officer?
Yes.
All right, and I guess your characterization of that conversation is that Mr. Stevenson was hemming and hawing about.
I guess hemming and hawing was not the correct term. I more meant he did not have a lot of information in regards to the actual assault. He did have a lot of background information, but he said he was sleeping when things kind of started happening. So that's all I would refer to.
And he woke up.
Yeah.
As part of the commotion, and then he saw Karen pushing past Katina
to get into the residence.
Okay. Well, I mean, was there much more to it than that, as far as you know?
Well, the remainder of the assault that had occurred. So that was the initial contact between the two people. And then she went down the hallway towards her room and was.
And this is your understanding based on your conversation with Karen?
Correct. This is right. Building the pieces together before I believe I talked to, I think this is after I talked to the victim and then came back inside to try and get witness statements, which you maybe up front to go to the paramedics, I think. I can't remember exactly.
Right.
Just look, for clarification, so that's not that portion that refresh your recollection, is that not the portion where you said he was reluctant, or is there another portion?
Right, I guess reluctant was the wrong term, Your Honor. I was more referring to, he said he was sleeping. I couldn't remember exactly what he had said during that time.
Okay, sounds good. You can proceed.
Well, and maybe we need to play it again, but so Jaquille tells you she shoved my girlfriend, and then you asked him, so things kind of started off heated. What's the background of the story? Is that right?
Yes.
Okay, so where was he supposed to have told you that Katina threw a punch?
I guess I'm not sure.
I'm gonna check. I don't think that was his testimony. I don't think he said.
Did you want to respond to the objection? I don't recall him saying that Katina threw a punch.
No, well,
I think he said his original testimony was that the boyfriend hemmed and hawed and was reluctant. He's now saying he used the wrong words. Never actually testified as to what he said. He definitely didn't say that. Did you want to rephrase that, or do you want to address the objection?
So I guess what my question is trying to address is, I think Officer Johnson's testimony is essentially that Mr. Stevenson was not forthcoming with the information, the part about my client throwing a punch. And so my question is, when was he supposed to have said that? Because he was telling the story, and then the officer asked for background.
Oh, okay, but maybe I missed the portion. Did he say that he wasn't forthcoming about throwing the punch, or?
That was, I suppose that was my understanding, but.
I don't remember him saying specifically the terms throwing a punch. I think that's what the objection is.
It's not in the record.
Exactly.
I think the officer ever testified that.
Officer never used
Mr.
those
Stevens said that a punch was thrown. I think he testified he hemmed and hawed and didn't felt that he was being less than forthcoming.
Correct. So I think the objection is to using that particular language that he never used. And then what you're trying to accomplish, I think you can accomplish by rephrasing the question. So I'm going to sustain the objection at this time.
So I guess this is perhaps just my understanding, officer. So is it the part, and you acknowledge that hemming, hawing, reluctance were maybe not the right terms, right?
Correct.
But still, I guess there may have, is it your testimony that at some point Jaquille seemed like he was trying to avoid getting his girlfriend in trouble?
That's what I felt, I guess, in my perception during the incident. And I would say that in my experience, that happens quite often. So that would be my understanding of that thing, that talk with him.
And so my point is he's telling you the story,
Right.
right? And then you ask for background information, right?
Correct.
So when was he's telling a chronological story, when would he have said the part that incriminates his?
And you asked me that earlier, and I said, I'm not sure.
Okay. After these couple of interviews with Karen and Jaquille, you also interviewed my client by the famous taco, right?
Yes.
And I think you testified that there was nothing about what my client told you that made you think this could have been a self-defense. Is that right?
Yeah, I did not believe so.
So just for impeachment purposes, Your Honor, I'm gonna approach with a separate body cam video from that evening, officer. And I'm starting at minute 51.
Okay.
Karen, can we make sure that it's turned up all the way so?
Correct. And I don't know, I really do think that it should work from there. I'm not sure when you logged in, if it.
I checked the checkbox. I think the issue is I hadn't installed those settings before, so I think my computer wants to be restarted.
Got it. Okay. So I get it. So make sure that if the volume could be as high as possible. That's the best we can do.
I don't know if I were to place the microphone by.
It just helps her though, not the jury.
Oh, okay.
Yeah.
And so I'm scared that she's rushing into my house. We already had this agreement. We already had this agreement about her leaving. She told me she was starting to leave, I think it was last Thursday, and that her family was coming to get her stuff today. Totally fine. So I got her stuff ready and put it by the door. And then she rushes into my house and then pushes me out of the way. I was so.
So you heard the part where Katina told you she was pushed out of the way?
Yes.
All right. And so in your mind, that was not something that might have raised a question about self-defense?
In totality of the circumstances, I do not believe so. Okay.
That's all I have for you, officer. Thank you.
Thank you.
So, officer, in asking a question based on the question that was just asked you now, she indicated that she was pushed out of the way.
Right.
She never indicated to you, to your knowledge of what you heard on the tape, that she ever punched her or struck her or threw her on the ground. Is that correct?
Correct.
Simply that she pushed her way into the house.
Correct. That was my understanding.
And that there was an agreement that the witness, the victim, was going to leave the house.
Correct.
And you made a determination that no legal process had been done at that point. Is that correct?
Correct.
Now, you said something earlier about she was going down the hall. And could you finish that thought you had?
Yeah, the victim
I'm going to object to hearsay, Your Honor.
You're gonna object to hearsay about him going down the hall?
I think it's about the complainant going down the hall. The source of the information will be what the complainant told him.
That's correct. I'm going to ask him what the victim alleged was done to her when she went down the hall.
which is hearsay.
Is it being offered for the truth of the matter asserted?
Being offered for the truth of the matter asserted why the officer was there and what he's trying to figure out. He's trying to figure this all out. He doesn't know whether it's true or not.
Okay, the objection is overruled. You can respond.
So back to, you indicated she was going down the hall.
Yeah, she pushed past the defendant, was going down the hallway towards the room, and then was grabbed by her hair from behind and then punched in the face.
So she was already, your understanding was she was already in the house past her.
Correct.
She was grabbed from behind, turned around and punched in the face.
Yes, sir.
And this was near the statement you received also from Miss Newton, is that correct?
Any questions from any of the jurors? And you can write them down if you do. I think I have at least one question. You can correct me, officer, if I'm wrong. I thought on your direct, you stated that it was the victim, Miss Lockwood, who stated that she shoved past, I think you said, the defendant.
Yes.
And then the defendant grabbed her by the hair and punched her. Is that your testimony? Okay. And so was it also your testimony that you, well, you didn't, based on your training and experience, you don't consider a shove to be a form of contact?
Not necessarily, Your Honor. I was more referring to it did not feel like a direct.
Off the record. Everybody got
Yeah.
some water? Ma'am, did you need some water?
I think I can.
I'm sorry? She said no, thank you.
Sorry, they're mine.
Why don't you get around?
Okay, you can be seated. Okay, right before we had the technical debacle, I think I asked a question about. Are you able to read back what my question was specifically?
The last thing I got was the Indian shove past the defendant, that the victim shoved.
Okay, so it looks like the record didn't pick up the question. My question was, in your training experience, do you consider a shove contact?
Yes, I do. In this circumstance, it did not feel like it as it was directed at the defendant. It was more her trying to get inside the residence, and she was kind of blocking her way.
Okay, and also when you gave testimony about the defendant's boyfriend, you mentioned you're not believing that he was forthcoming. Was there any particular reason other than the fact that they were in a relationship that caused that, or was there some body language or something that caused you to believe that?
No, it just, I guess in my, again, a training experience, sometimes it's hard to believe the spouse or partner, because I've seen a lot of times where they would say whatever they had to say to protect their person. So I guess forthcoming probably wasn't the best route, but that's kind of what I was referring to.
Oh, sounds good. Okay. Any questions from the jury? Okay. Any redirect and then cross-examine based on my questions?
Just one follow-up.
Oh, there's a question, Mr. Bigelow. I'll let you ask your questions because you might address it. Okay, and then I'll take, you have a question? You wrote it down, he's gonna take it and bring it to me. And Mr. Cartwright, you can proceed. Oh, no, you can ask your question.
Okay.
Yeah.
So just to redirect to a question you were just asked, and to be clear, no one ever said that the victim was up in Miss Newton's face, or that she had attacked or assaulted her, simply that she had pushed her into the home.
Yeah, it was described like a heated argument, and this has been bubbling under for a while, but that she was trying to get into the house to get to her things, not that she was going after.
And the fact that both parties indicated that she had grabbed her from behind by the hair would indicate that at that point she's not assaulting.
Correct, in that moment, correct.
Mr. Coons, any cross based on my questions?
No, Your Honor.
Okay. If the councils can approach. Okay, an officer, what did the defendant give any reason, or was there any reason given to you as to why the defendant left the house?
I think she said she was scared. I'd have
The defendant said that?
Yeah, I think she said she was scared and didn't know what to do.
Okay.
But I can't remember exactly.
You can't recall?
No, I
Okay,
can't.
sounds good. Any cross-exam or redirect based on that question?
So she said she was scared. Did that lead you to believe that she was scared that she was going to be assaulted, or she was scared because of what had happened earlier that she might get arrested?
I think it seemed like she was scared she was going to get in trouble because she was remorseful of what had happened.
Mr. Kitina, no, was there any cross based on that? or did you need an opportunity?
Just a few seconds.
Take your time.
Further questions? Thank you, Your Honor.
Thank you. May this witness be excused?
Yes, Your Honor.
No objection.
Thank you, officer.
Thank you.
Oh, let me also advise you, there is a sequestration order, so you can't discuss any portions of your testimony with any other witness. Thank
Yes,
you.
Your Honor.
You can call your next witness.
This time, Your Honor, people call Karen Lockwood.
Okay, when you stop there, I want you to raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I swear.
Okay, you can have a seat. There's a microphone that's in front of you, and the lady behind you is my court reporter. She has to take down everything being stated here today, so your responses must be verbal. They must be loud and clear so we can hear. They can't be head nods or shakes or mm-hs and uh-huhs because we can't read those into the record, okay?
Okay.
If there is an objection from either of the attorneys, you would stop speaking. I'll give a ruling on the objection, then I'll tell you if you can give that answer or not, okay?
Okay.
Okay, and then if you need a question repeated or you can't hear anything, you just let us know. State your first and last name and spell both of them.
Karen Ann Nicole Lockwood, KarenAnnene, NICOLE. Lockwood is LLCKWOOD.
You can proceed.
Now, Ms. Lockwood, are you familiar with Katina Newton?
Yes,
And how are you familiar with her?
I've known her since I was 17.
Okay. How would you describe your relationship with her in the past?
We were both goofballs. We were young when we first became friends. We did everything. We went to prom together. She came to graduation parties, she came to birthday parties. We'd spend summers together, breaks together.
They're pretty good friends
Yes.
for a long time.
Yes.
I want to remind you to keep your voice up. So last November, prior to being in Michigan, where were you residing?
I was in Alabama.
Okay, did there come a time when you came to Michigan?
Yes, my father passed away in October and I got a plane back to Michigan.
Okay. And did there come a time when you moved in with Miss Newton?
November 4th.
Okay. And when you moved in, what was the arrangement?
The arrangement was for me to move in. I'd stay in the guest room and I paid $279 a month.
I worked and just basically stayed there until I got on my feet.
Okay, have you two ever lived together before?
No, we have not.
Okay, but you've known each other since you were teenagers?
Yes.
And so you came back to Michigan,
Mhm.
you moved in with her?
Yes.
So at some point, it sounds like maybe things between the two of you went a little sour, would that be correct?
Yes.
And what was in your mind the cause of that?
In my mind, I feel like she felt that I took advantage of her. And I was very verbal when she had an issue. I said, okay, I understand. I will do better. And it never was good enough in my opinion.
Okay. Now, did there come a time, probably in March or April, when she requested that you move out of the house?
Yes. What happened was I left the door open and she texted me around March asking to move out. I'm sorry.
Okay, did you indicate to her you were going to move out?
Yes, in the summer.
Okay. Now, did there come a time around the 13th of April, you're aware of that date, there was an incident that happened that day, is that correct? Now, just prior to that, when you maybe spent a night or two away from the home?
Yes.
And where did you stay?
I stayed in Southgate, Michigan at a hotel called Lockwood.
Okay, and why did you stay there at that time?
I was under the impression that I didn't have any rights to stay at the house anymore. I was under the impression she spoke with the police and they said there was no lease agreement, so I had to move out or all my stuff would be in a storage unit.
So you thought that you were required to move out at that point?
Yes, I did not know my rights.
Was there a time when you came to realize that maybe that wasn't true?
Yes.
And is that right around this time?
When the incident happened, yes.
So let's go to what happened at the incident. So I'm going to take you to the 13th of April, 2023. You at the location of 1140, I believe that's Kaywood Street, Lansing, Michigan, 48915.
Yes, sir.
And who else was living at that address at that time?
It would be her boyfriend and Miss Newton.
Okay, you see Miss Newton in the courtroom today?
Yes.
And could you point her out something that she's wearing?
She's right there. She's wearing the black top with blonde hair.
We ought to let the record reflect that she has identified.
Any objection to identification?
No, Your Honor.
Identification is noted.
So you had been in the house for a couple days.
Monday.
Back to the home. Did you still have belongings at the house?
Yes, I did.
Come a time when you tried to go in the house?
Yes, that night.
Okay. And what was the first thing you did when you tried to enter the home?
While I was driving up the street, I let Miss Newton know that I was coming back.
Okay, and how did you let her know?
I texted her.
Okay. And did she respond to that? Don't tell me what she said, but did she respond?
Yes.
And was it your understanding that you could go back to the home from her?
It was not from my understanding.
I'm sorry?
From my understanding, no, it was not from my understanding that she said I could go back.
Okay. But you were under another impression at that time because you must have discussed your legal rights with someone?
Yes.
Okay. And did there come a time when that night when you tried to enter the home?
Yes.
And what happened when you tried to enter the home?
I pulled up to the residence. Miss Newton was already standing outside in the doorway of the
Okay.
home. She said, I cannot move my stuff back in. If I wanted to, I would have to get a lawyer. And I said, okay, I will do that when I bring my stuff back in. She said, you're not moving your stuff back in. I said, I will call the police back. She said, okay, call the police. I said, okay, I will when I move my stuff back in. I proceeded to walk up the stairs, Miss Newton standing by the door. I walked sideways past her. I got to my bedroom. I looked at my bedroom, everything was out of there. The belongings that I had were no longer in the room. Next thing I know, I'm getting pulled by my hair. I turn around and I'm punched in the face.
Okay, so you said your belongings were moved out of the room. Did you remove everything out of that room?
No, sir.
So were you a little surprised when you got there and nothing was in the room?
The only thing that I can recall that was in the room were her curtains and her treadmill.
Okay. Now you said how did you, let's go back when you said you entered the home. At any point, did you shove her, push her out of the way to get in the home?
No, sir.
Said you went past her.
Mhm.
Describe
that a
how you-
yes?
Yes, sir.
Describe how you did that.
I walked up the stairs. She was standing on the left side of the door, close to the door. I walked in the door, got up, walked sideways. I did not brush past her, and I entered the home.
So was the door slightly open?
The door was all the way open.
Okay.
It's the door that you push in. It doesn't come out. It pushes it.
So you said you walked past her sideways. That means you kind of went sideways like
Yeah,
this?
so she was standing like you are right now, and I approached the stairway and I walked sideways this way past her.
That's what went to the bedroom.
Yes.
At any point, did you strike her,
No, sir.
pull her hair,
No, sir.
push her out of the way?
No, sir.
And how far is the bedroom from the front door?
Mm, If I'm guessing, it takes 30 seconds to get to the bedroom.
Okay, but it's a little distance from the door, is that correct? Front
Yes.
door? Is there a hallway between that and the front door and the bedroom?
Yes.
Now, at some point you said she grabbed your hair. Where were you at when the hair
I
was
was
grabbed?
standing in the doorway of my bed.
And how was your hair that day? Was it kind of, you wear it the same way you do today?
No, it was in longer braids down to my back, and they were locks.
Okay, so you had even longer braids.
Yes.
Now, when you say she pulled your hair, can you describe that?
I walked into the room. I didn't expect anything. I felt like a little tug, and I turned around. Like a little tug.
And then what happened when you turned around?
I was punched.
You may.
Now, I have a series of photos here, Ms. Lockwood, that were taken by the officer who responded to the scene. And they appear to be photos of you, is that correct?
Yes, sir.
Are those accurate representations of how you looked when the officer arrived that day?
Yes.
And you had a cut across the bridge of your nose?
Yes, sir.
Initially, did you request medical treatment?
No, sir.
Did Lansing Fire Department respond though?
Yes.
And when they were there, did you seek medical treatment from them?
No, sir.
Were you upset that night?
I was in disbelief.
What were you in disbelief about?
I was in disbelief that someone that I grew up with would do that to me.
Sounds like things have been working up a little frustration. Say that's true.
Yes.
And did you call the police that night?
Yes, I did.
And do you know how long it took them to get to that location?
No, sir.
Okay, was there anybody else in the house that night?
Yes, the boyfriend,
And what is his name?
Jack. That's as much as I know. I do not know his last name.
Okay, so you don't know his last name, and he was in the house.
Yes, sir.
Was he present that night during the assault?
Yes, sir.
So for your mind, he would have witnessed the whole assault.
Yes, sir.
Now, following the assault, you stayed at the property?
Yes, I stayed at the property.
Yeah.
Until
Now, did Miss Newton stay with you there till the police arrived?
no, sir.
And how quickly did she leave after the assault?
I got on the phone with 911. Next thing I know, she walked outside in her barefoot to her car.
Okay. Did she leave in that car to your knowledge?
Yes.
Upset when the police arrived?
Yes, sir.
Describe it a little.
I was going through so many emotions that night. I was crying. I was angry. I didn't expect it to escalate that much. I was scared because I didn't know what my situation was going to be. I thought this was not going to escalate this much. Because as long as I've known her, she has never put her hands on anybody. So for this to happen, I was scared and I was going through many emotions for the last couple days.
Following this assault, did you retaliate against her in any way? Did you strike her?
No, sir.
Pull her hair?
No, sir.
Did you push her?
No, sir.
Is that because you were a little stunned?
Yes, sir.
Had any contact with Ms. Newton since that night?
No.
You reside in Lansing now?
No, sir.
Where do you reside now?
355 pound, 35585 pound road, Richmond, Michigan.
That's a little south of Flint.
Not south of Fort now.
South of Flint. Yeah. You live about how far? 2 hours, hour and a half away?
Yes, sir.
Your nose was cut like that and bleeding. Is it painful?
Yes, sir.
Can you describe that?
When it happened, I felt it. My glasses were broken. Cut my glasses, cut my nose. It was bleeding for about an hour.
It was. So let's hear about this. It wasn't just that your nose was cut. Your glasses were also broken too.
Yes, sir.
So obviously they're not glasses from the last day.
No, sir.
And that was a direct result of being punched.
Yes, sir.
Where did that punch land?
Was it
Do you recall?
Mhm.
Right square in the nose. You know if that was with a closed fist or an open hand?
No, sir. It happened so fast.
Questions at this time?
Cross exam.
Thank you, Your Honor. Good afternoon, Ms. Lockwood. I want to go back a ways and learn a little bit more about how you got to know my client Katina. I think you said you met when you were 17.
Yes, sir.
And was that in high school?
No, it was in a college program where everybody that was looking to go to that college would go spend a week or two there.
Okay. And so, is this like a summer thing or?
Yes, it was a summer thing my junior year of high school.
Okay. And are you and Katina the same age?
She is a year and a couple months older.
Okay. So this would have been, well, I guess, are we the same grade?
She was about to graduate.
Okay. Well, so it's summer, so she would have graduated.
No, she was about to graduate that year, and I was going to graduate. I was in junior year at that time.
Okay. And sorry, what time, was it in the summer? Do I have that right? Or no?
Yes.
Okay. So was it the summer between sophomore and junior years?
Yes.
All right. And you were 17 at that time?
Yes.
Okay. And so you have turned 18 during your junior year?
I'm sorry, let me correct myself. She graduated early before me. She was a senior. She already graduated. I was going into senior year. She was gonna start the program and I was gonna start the program after I graduated.
Okay. So you met when you were 17?
Yes.
Now you told Officer Johnson you met when you were 15, is that right?
No, sir.
Your Honor, may I approach?
You may.
Ms. Lockwood, I am.
Let me stop you really quickly because you had an adapter with you. Is that correct?
That's right.
I think Mr. Bigelow believes that if you have an adapter, it'll work.
There's, Sean.
Starting at 1 minute 46 seconds into Officer Johnson's body cam of that. His interview with you. Okay, so you told the officer that you knew Tina since you were 15, right?
Yes, I did.
Okay, were you just confused or is that something?
Yes.
Okay. And did you go to the same high school or no?
No.
Okay, and what was the college program that you went to?
MCTI in Kalamazoo,
Which, and do you know what that stands for?
Michigan Career Technology Institute.
Okay, and then the two of you did attend college there together at some point?
No, we did not.
Oh, so you just met in this program, right? Okay. And and how would you have how would you describe your relationship?
We were goofy. We always had fun. We had our arguments here and there, but we always resolved them. We went to prom together. We go shopping together, go to the movies together, spend breaks together.
Right, and I guess would you have described her as your best friend or?
Yes.
Okay. But just from meeting in that one program.
We met in the program and we caught in contact, kept in contact.
Okay. So I think you said November 4th is when you entered into a rental agreement.
There was no rental agreement. There was nothing signed.
Was there an understanding?
Yes.
Okay. Was it, generally speaking, you would pay rent to stay in one of her bedrooms?
Yes.
Right. And at some point, did you fall behind?
No.
You did not?
No, sir.
Okay. There were no late payments?
There was late payments.
Okay. Were there ever any non-payments?
When I was about to move out, yes.
You said you stayed in a La Quinta hotel for one night?
Yes, sir.
And this is after moving out from Katina.
was mistaken what her testimony was. I don't think she ever indicated she moved out.
I didn't hear what you said.
I don't think she ever indicated for the record that she moved out. I think that's
She actually said that she didn't pay when she was moving out. What did you say? What was your
Well,
question?
I asked, the implication being right before the incident, issue that, she had stayed at a La Quinta for one night moving out, and I can recharacterize moving out.
Well, when you asked her whether or not she missed or didn't pay rent, her response was she didn't when she was moving out, so she said it.
And so you stayed at La Quinta for one night? Is that right?
Yes, sir.
Okay. Now, did you stay there by yourself?
No, sir.
All right. Stayed with your boyfriend? So-
Yes, sir.
Okay. Now, did you tell Officer Johnson that you'd stayed there for 2 nights?
Not that I recall.
Yes, with my boyfriend.
So that same video, I'm gonna start it at 2 minutes and 10 seconds for you. Approach, Your Honor.
You may.
In my car, I spent the week, 2 days with my boyfriend. No, my boyfriend lives in Lincoln Park. That's for
Right, so there you say you spent 1 week and then correct yourself 2 days with your boyfriend, is that right?
Yes, sir.
All right, and that was at the La Quinta?
Yeah.
And I'm sorry, what city or whereabouts was that?
Southgate.
Southgate, which is in Metro.
Wayne County.
Okay. And I think your boyfriend lived in Lincoln Park at the time?
Yes.
Okay. I don't know his living situation. Were you allowed to stay at his place?
No.
Okay. Is it someone like live with parents who didn't want you there, or what was the situation, I guess, where you couldn't stay there?
His mother was this.
Okay, and so I guess do you remember today, was it 1 night or 2 nights that you stayed at the hotel?
Today I remember 1 night.
Okay. And is my understanding you had some of your belongings, but not all of them from the house?
Yes.
Okay. And you were trying to move back in the ones that you did take with you?
Can you restate that, please?
So you're trying to move back in on April 13th, right?
Yes, sir.
All right, and bring the stuff that you moved out back with you?
I guess I'm gonna object. I don't think she ever testified she moved out of the house. Trying to characterize this as she testified earlier that she moved out. I don't remember that testimony.
She did testify on a direct examination that she left because she thought she was required to move out. So to the extent that she was under the impression that she was required, but then she stated she was advised of her rights, so she was gonna come back to the property. So I don't find his question to be inappropriate based on that. You can answer the question, the objections over.
So, okay, April 13th, you're trying to bring your belongings back to move back into the home, right?
Yes, sir.
And did you give any advance notice that you were doing this?
No.
Right, when did you show up?
April 13th.
What time of day? Right, late at night?
Before midnight.
After 10?
Yes.
Okay. And if I were to show you a screenshot of some text messages exchanged and you review that, do you think that would help refresh your memory about when you would have shown up that night?
Guess I'm gonna object. Sounds like you're saying to me.
I'm asking if it'll
And I've
refresh.
never been presented with these.
Well,
screenshots.
this is, she didn't say she didn't remember, I don't think. Are you trying to impeach her? Is that what's happening?
No, I'm trying to just refresh. I'm going to have her look at this, refresh her recollection.
As to the time she arrived? You said
Yeah.
what the question is?
Yes.
Okay. She didn't necessarily say she didn't remember. She said that she arrived late night. Maybe you can ask her specifically. Did she remember the time exactly?
Remember the time exactly?
Nothing.
Okay. Does 11 o'clock sound right?
Yes.
Okay. You testified on direct examination that when you entered the home, you kind of walked sideways past Katina to get in the home. Is that right?
Yes, sir.
You made no physical contact,
No, sir.
and then you're walking into the home, correct?
Yes, sir.
And right when you walk in, there's a fireplace to your left. Is that right?
Yes, sir.
Is that correct?
Yes, sir.
And then you walk past the fireplace, and then there's a hallway to the left, correct?
Yes, sir.
All right, so then you take a left down the hallway. You said you got to your room, and that's where the hair pulling and punch happened, right?
Yes, sir.
So how far down the hallway do you have to go to get to what was your room?
Walk past the fireplace, and then there's the hall where the bathroom, the room, and her room is. And I just walk past the fireplace and make a little turn and walk straight. Probably two steps, and there's none.
Okay, so you take a left to go down the hallway, right?
Mhm.
Okay,
Is
and
that a
then
yes?
sir.
and then is your room on the left hand side or the right hand side when you're walking down the hallway?
My room's straight.
Like at the very end of the hallway, there's
The hallway is, if it was longer, like that long, not that long. There's a closet in that hallway, bathroom, my room, and her room.
okay. So walk in, you take a left, you're walking down the hallway. What's the first door that's on your left?
The first door that's on my left is the closet.
What's the first door that's on your right?
That's her room.
Okay, is there a second door on the left?
On my right, there's a bathroom.
Okay, so on the right, it goes Katina's room, bathroom, and then your room is on what side of the hallway?
Can I correct you? It's, her room is on the side next to the fireplace.
Okay.
Then it's the closet across. One step over, my room,
Next,
right next to my room, the back.
okay, next to the closet.
Yeah.
Okay. I'm guessing this happened pretty fast. Do you know what hand Katina used to grab your hair?
No.
Do you know what hand she used to throw the punch?
No.
You testified that your glasses were broken, is that right?
Yes, sir.
Okay, and was that immediately apparent?
Yes, sir.
Like, were they broken in half or?
The lens popped out.
Oh, okay. Okay, so may I approach you on?
You may.
All right, so this is that same body cam as Lockwood, and it's paused at 1 minute, 2 seconds, okay? Right, in that freeze frame, do you see some items in your right hand?
Yes.
All right, including your glasses?
Yes, sir.
Are those the glasses we're talking about?
Yes, sir.
Do you see a glare on both sides of them?
Yes, sir.
All right, so which side did the lens pop out of?
My left side.
Okay, but there's a glare on that, right?
Yes.
Okay, so what's the glare coming out of?
My lens that I popped back into my glass.
I see. These are prescriptions?
Yes, sir.
That's all I have for you. Thank you, Ms. Lockwood.
Redirect.
So when you were on the video camera, and speaking with the officer, you were upset.
Yes.
So you may have said 15 instead of 17, correct?
Yes, sir.
You were upset. And when you said, you did correct yourself. You said
Objection
today
leading.
one night. And then you said
There's an
2
object, yeah, there's an objection.
Leading.
Said leading was the objection?
nights.
Okay, he'll rephrase.
Were you upset that night?
Yes, sir.
Pretty calm today, isn't it correct?
Yes, sir.
Had adequate time to reflect a little bit on that night.
Yes, sir.
And I think that quickly.
Yes, sir.
Admitting you made a mistake about whether you were 15 or 17, correct?
Yes, sir.
Whether it was 1 or 2 nights.
Yes, sir.
It is. You had some late payments,
Yes,
right?
sir.
And you missed the payment towards the end.
Yes, sir.
Was that after you were asked to leave?
Yes, sir.
Why were you asked to leave?
In detail.
Be brief.
In March, I left to go somewhere.
Right.
I walked in the house, shower, walked back out the house, forgot something. And I walked out the house, I locked the door. I always lock the door. She texted me around 3 o'clock. I left the house 1 o'clock. She texted me, says, you didn't shut the door all the way. The alarm was going off. You almost let my dog out. You need to be out by the sun.
So she was upset. The alarm had gone off.
Yes, sir.
Had nothing to do with rent.
No, sir.
Okay, that's good.
Any questions from the jury? Okay, I think I have one question. Ms. Lockwood, did you ever report to the officer that you shoved past the defendant to get in the house? Sorry?
Sorry, no, ma'am.
Okay, thank you. Any redirect based on that? Any cross based on that? Still no questions from the jury? May this witness be excused?
I have no further questions.
Thank you. Ms. Lockwood, there is a sequestration order, so that means that you can't discuss any portions of your testimony with any other witness, okay? Thank you. You may be excused. You can call your next witness.
Your Honor, at this time, these people are going to rest their case.
Okay. Is the defense going to be calling witnesses, or do you need a brief recess?
I don't need a recess, Your Honor. And it's ready. I'm ready to call Jaquille Stevenson.
You can call your first witness. Oh, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can have a seat. There is a microphone that's in front of you, and the lady behind you is my court recorder. She has to take down everything being stated in the courtroom. So your responses must be loud. They must be verbal. You can't do head nods or head shakes, okay? You also can't do mm-hms and uh-hs because we don't understand that when we write that in the record, okay? If there's an objection from either attorney, you would stop speaking. I'll make a ruling on that objection. I'll tell you if you can give your response to the question or not, okay? State your first and last name and spell both of them.
Jaquille Stevenson, JAQUILL STEVENSON.
You can proceed.
Your Honor. Jaquille, do you go by a different name?
Yeah, Jack.
Jack?
Yeah.
Okay. You mind if I call you that?
Yeah.
You do mind, or I can call you that?
Yeah, you call me that.
Okay, thanks. Jack, do you remember the night of April 13th of this year?
Yes,
Okay, is there something that happened that sticks out in your mind?
yes,
Yes is the answer.
yeah.
Okay. What was that thing?
Thing was, I was on the couch, laying down, I heard a big boom at the door. And then when I heard the boom, I woke up and I seen Nicole, I seen her,
Let me pause you right there. When you say Nicole, are you talking about Karen Lockwood?
yes,
Okay, and that's her middle name.
I didn't know her name was Karen.
Okay. To you, she goes by Nicole.
Nicole, yeah.
Okay. So you hear a boom, you see Nicole there, then what happened?
When I woke up, I seen her push Katina into the fireplace.
Okay. And so let me stop you there. So this couch, where is it positioned in the home?
It's right in front of the fireplace, TV, doors on the left side. And, it's a kitchen on the right.
Okay. And so let me ask you this. Do you remember talking to a police officer about this?
Yes.
In the home?
Yes.
The couch that you were on when you were sleeping, is that the same couch you would have been on when the officer was asking you some questions?
Yes.
Okay. And so saw, correct me if I'm wrong, you saw Karen push Katina into the fireplace?
Yes.
Okay, and when we say into the fireplace, are we talking about the mantle, the wall, or like in the fireplace itself?
No, so the fireplace is like separate. It's not like connected to the wall or anything. It's like an electric fireplace. So it's just like big and it's just like right there.
So she didn't like end up like in Santa Claus, like in the heart?
No.
Okay, all right. And then at some point, did you see Katina punch Karen?
After the initial first strike.
Right. So I'm sorry, did you say first strike or fresh strike?
No, first strike.
First strike.
Yeah.
Okay. So is that the push you're describing?
Yes.
From Karen to Katina?
Yes.
And now where did the punch occur?
Like around the corner from the fireplace, like you just take 2 steps and it's like right, a little doorway right there.
Uh-huh.
And then her room, Nicole's room is like just like straight ahead.
Okay.
But it's a little doorway right there, and that's what happened at right there.
Okay. And so you say this is like a literal 2 steps, like right around the corner?
2 steps. Yeah.
Okay. So between Karen pushing Katina and Katina punching Karen,
yeah,
how much time elapsed?
It was that much time. It happened really fast.
Okay.
Really fast.
All right. Now let me ask you this. You were asleep prior to this point.
Yeah.
Were you in a deep sleep or a?
No, I wasn't in a deep sleep, because if I was in a deep sleep, I wouldn't heard none of that stuff at all.
All right. So were you pretty aware right away?
Yeah. Well, yes.
Did you try to hide anything from Officer Johnson?
No.
At some point, were you on the phone with the team?
Yes.
Okay. And she had left the home at some point.
Yes.
Okay. And did you give your phone to Officer Johnson?
Yes.
To talk to Katina?
Yeah.
And then at some point, did Officer Johnson leave your home?
Yes. After he took down my statement, he left.
Okay. Did you have another contact with Officer Johnson that night?
No. Oh, yes. When I walked to meet Katina at the Biggie, I think.
Okay. Like on Saginaw,
Yeah.
West Saginaw. I'm near where the two Oakland and Saginaw converge.
Yeah.
Right, with famous taco maybe.
Yeah.
Okay. And what was the purpose of that? Were you?
Oh, I was just going up there to make sure everything was okay.
Okay. And did you?
With Katina.
Sorry. Did you retrieve Katina's car?
Yes.
Okay. How long have you and Katina been dating?
Going on 5 years now.
5 years?
Yeah.
Okay. Pretty serious relationship.
Yeah.
All right. You care about her?
Yeah.
Lie for her?
No.
Would you lie for her in court?
No.
Thanks. That's all.
Cross exam.
Stevenson, it's your testimony today that you saw Miss Lockwood push Miss Newton into the fireplace.
Yes.
Did you indicate that to the officer that night? We have seen the tape. It was played in this courtroom earlier today. Did you say that to the officer?
No.
All right. No further questions. You're lying today.
Whoa, 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 whoa.
Strike that?
Yes.
Strike that. I'll strike.
Thank you. Redirect.
Yes, thank you. So, Jack, I would like to refresh your memory with that same video just referenced, okay? And maybe that'll help refresh your memory about what you told the officer that night?
Yeah.
Sure. All right, I'm gonna start it here at 3 minutes, 1 second.
Okay.
Where she like shoved your girlfriend? You're nodding your head.
Yes.
Okay, that's what you told Officer Johnson, is that right?
Yes.
So you weren't fully honest in court because you denied telling him that, didn't you?
Yes.
Okay, but in fact, you did tell him that.
Yes.
On the night where this happened.
Yes.
Right after it happened.
Yes.
All right, that's all. Thank you, Jack.
Okay, any questions from the jury? If you do, just write it down. Council wants to. Okay, we don't have any other relevant questions at this time. I believe so. This witness can be excused. Is that correct?
Questions?
Yes, ma'am.
Okay, thank you. You may be excused from the bench. There's a sequestration order, so you cannot discuss your testimony with any other witness, okay?
Okay.
Thank you. You can call your next witness.
Thank you, Your Honor. I'd like to call my client to the stand. I'm sorry, Your Honor. At this point, could we take just a brief recess?
You may. We, you can have a seat. Okay, we're gonna take a brief recess. This is an opportunity for you to stretch, use the bathroom. You're not at liberty to discuss the case or deliberate at this time. It's just a brief recess so we can take care of some things in the courtroom. All rise for the jury.
How I view this case and what we think our best route
Yeah.
would be. And in doing so, we agreed prior to today that it'd probably be best if you testified.
Yes. Yes.
Now, do you understand that you have an absolute right under the US Constitution not to testify?
Yes, I do understand.
Okay, and do you understand that if you decided not to testify, that Judge Simmons would instruct the jury they can't use your silence against you?
I understand.
All right, now do you also understand you do have a right to testify?
Yes, I do.
All right, and acting on my advice, do you think it would be wise for you to testify?
Yes.
Right, knowing all of those things, is it your choice to testify this afternoon?
Yes, sir.
Okay.
And you understand that once you testify, that the prosecution does have the right to cross-examine you?
Yes, ma'am.
Okay. Any additional questions?
No, thank you.
Okay, thank you. We'll go back on the record in about 5 minutes, just because jury, some of them dispersed down the hallway. Newton. I previously placed you under oath and you're still under oath, okay? Have a seat. Council, and you heard the rules before, so you know the rules. And because I turned the fan over there on, I need you to talk like you're yelling.
It's a little bit, at least for me, a little bit hard to.
Okay, we're gonna yell. Can you hear me? Yep. Okay, everybody's gonna use that same volume.
All right, so Katina, I'm not yelling at you, okay? All right, I want to talk to you about, well, I guess I want to talk to you about your relationship with Karen Lockwood.
So my,
Speak up.
so my relationship.
When did you meet Karen?
Oh, okay. I met Karen in college in the MCTI program,
Okay, so MCTI, what is that?
Michigan Technical Institute.
Okay, and the C is college?
I think
or-
I think it's Michigan, Technical Institute. I'm sorry, I don't know if this is important.
Okay, and so when you say you met her in college, did you have college courses together?
Well, we had the summer courses, which were pre-college courses, so that we could decide if we wanted to go to school there.
Okay, and eventually you did, is that right?
I did, yes.
And she did not?
Correct.
Okay, you maintained a relationship?
Yes, correct.
Were you friends over the course of a period of time?
Yes, we were.
All right, and then at some point last year, well, let me ask you, at some point last year, did Karen come to live in your home?
Yes.
How did that come about?
It came about because her father had passed and she was currently living in Alabama. I wanted to give her somewhere to live so that she could get her things together and get herself together and be up here with her father for a few months.
What was the idea that she'd pay rent?
Yes, it was $279, I believe.
Okay, 279 seemed, how did that number come to be?
Yeah, absolutely. It was just to take care of the extra water that was being used, and I allowed her to use like my washer and dryer and took care of the laundry, soap, and food for her as well.
Okay, so essentially rent and utilities?
Yeah.
I see. And was she to pay you monthly?
Yes, sir.
And did at some point she start making late payments?
Yes, sir, the whole time.
Okay, so the whole time, so even right after
Moving in.
Okay. At some point, did she stop making payments?
Yes, sir, 2 months before she left.
2 months before she left?
I know, Jack, sounds like leading her food first, and like she's saying a lot of yes.
Okay, did you want to respond to the objection?
Your Honor, I think it was an open-ended question. It was, did she?
I think the last question, at least, was, any time did you start making late payments? That's not a leading question. I don't think we have a problem, so I'm gonna overrule the objection.
So at some point, did she begin to miss payments?
Yes, sir.
And you said 2 months earlier?
Yeah.
The incident that we're all here for today, that took place on April 13th.
Yes, sir.
And so was it sometime in February then that she stopped paying rent?
Yes, sir.
All right. And I guess without getting into details, were there more things that led to you wanting her out of your home?
Yes, sir.
Okay. And now, did you formally evict her?
No, sir.
Did you give her a notice to quit?
I gave her notice to leave.
And when you say notice, is this a legal document?
No, sir.
Okay. How did you give her that notice?
We had talked about it via text and also in person.
Okay. And did she?
She did leave, yes.
Okay. Do you remember the date of that?
I believe it was, I believe it was April 12th. It was pretty early in the morning based off of my video for now.
Well, okay. So let me stop you there. Had she been gone for 1 night or 2 before she?
I believe 2.
2. Okay. So this was April 13th, the night of April 13th.
Yeah.
So was it April 12th or April 11th?
I believe it was April 12th. Maybe it was one day and going on a second.
How about this? I think you briefly mentioned you have a like a home security system?
I do.
Okay, is that equipped with the camera?
Yes, sir.
And did you at some point retrieve some footage from one of your cameras?
Yes, sir.
And what, just generally speaking, what would that footage have been of?
Her moving her things out.
Karen moving her things out?
Yes, sir.
Okay, and if there were some date and time stamps on there, would those be accurate?
Yes, sir.
Okay. And did you at some point provide me
Yes.
some of the video?
Yes.
And I guess what you provide me is an accurate representation of what happened.
Yes, sir.
All right. Your Honor, at this point, I would move to admit Defendant's Exhibit A, which is a series of short videos.
You may.
May I approach, Your Honor?
You may.
Hey, Katina, I'm gonna show you just a video of that Simply Safe video. Now, do you take a look at it and maybe the menu bar, my cursor talking?
Can you speak up?
Yes.
And just look at this and let me know if this refreshes your memory about when Karen moved some of her items out of your house. Has your memory been refreshed? Do you see where there's a series of numbers beginning with 04?
Yeah.
Okay. Okay, does this refresh your memory?
Yeah.
All right, so was this April 11th or April 12th when she would have moved out?
It's April 11th.
Okay, so she had been gone for 2 days before she came back to the home?
Correct, yes.
Okay. Okay, well, come back to this. Yeah. Okay, so what was your understanding of? Well, let me ask you this: Did on April 11th, did Karen remove all of her items from the home?
No, she left 2 items.
Okay, what were those items?
It was a bed frame and a mirror.
Okay, so some larger items.
Correct.
All right, and on April 11th of this year, what was your understanding of the relationship between you and Karen?
We were no longer friends.
Okay, no longer friends. What about what was your sense about her tenancy in your home?
To my understanding, she had moved out.
Okay. She gave up her room?
Correct.
Okay. Fast forward to April 13th, Karen showed up at your home?
Yes, sir.
All right, and did she give you any notice about that?
She texted me right before she arrived.
All right, and do you remember when that was, like what time of night that was?
I believe it was about 11 o'clock.
Okay, and so did she, said right before she arrived, are we talking about a matter of minutes or?
Yes, a matter of 5 minutes.
Okay, so you get a text saying she's coming back?
Yes.
And then she's there?
Yep.
Right. Now, what happened when she approached the door?
Yeah, so when she approached the door, she pushed me, and I asked her to please not push me. And at that time, she did grab my forearms and slam me into my fireplace.
Okay, and so fireplace being like the wall around the fireplace?
No, the actual fireplace.
All right, did you fall down?
No, I didn't.
Okay, so I guess like, how high does the fireplace go up?
It's about, I would say, like rib.
Okay, you didn't end up like inside the fireplace?
No, there's nothing to end up inside of.
And then, well, I guess at this point, how are you feeling?
I feel really frustrated.
And I'm sorry, when I say at this point, I'm talking about the night of April 13th, not today.
Oh, I'm sorry.
So, when Karen came into your home, how were you feeling?
When Karen came into my home, I felt really scared and I felt upset. Because she had just pushed me on multiple occasions, and that's supposed to be my friend. And I was just trying to help her.
You were just, I'm sorry.
I was scared.
Okay. You were just trying to what?
Help her.
Help her?
Yeah.
By providing a room for her?
Yeah.
And on April 13th, are you okay?
Yeah.
On April 13th, well, let me ask you this. So at some point, did you punch Karen?
Yes, sir.
Okay. Where did that happen?
Yeah, after she pushed me in the fireplace, her and I both took about 2 steps towards like the door, the walkway. I don't know how to explain it, but it's not a doorway. It's like a walkway to my hallway.
And at that time, I had grabbed her and I punched her.
Okay. You grabbed her how?
I grabbed her hair and I punched her.
Okay, so you grabbed her hair with which hand?
I believe it was my left hand.
Okay, and then punched her with your right.
Yeah.
Okay, and how you said about 2 steps? Are we talking a literal 2 steps?
Yeah, an actual 2 steps. My like walkway thing is right next to it.
And when you threw the punch, were you still feeling scared? Did you leave your home that night?
I did.
What prompted that?
I wanted to separate myself from her because she was still yelling at me into my face.
Okay. Now, to your knowledge, did she call the police?
I believe so, yes.
Okay. Did anyone else call the police that night?
I did.
Okay. Why did you do that?
Because I didn't want to run. I just wanted to be separated from her so I was safe. And I called on my own to be like, hey, I'm not running. I just want to be separated.
Yeah, I think that's all the questions I have for you. Thank you.
Cross examine.
So on the night of this incident, you had contact with officer from Lansing Police Department, is that correct?
Yes.
He was in here earlier today and testified.
Yes.
At any point, did you indicate to the officer that Karen, Nicole pushed you into the fireplace?
Yes, I did.
Is that on the tape somewhere?
It possibly is, but I'm not 100% sure because I haven't seen anybody came to me.
So the officer then would not be telling the truth about what occurred.
Possibly, but I'm not 100% sure how he felt.
Did you not tell the officer you were apologetic about this?
Yeah, I did. I will.
Not tell the officer you grabbed her by the hair and punched her in the face?
I did something like that.
Did you tell the officer you were defending yourself that night?
I did tell him she pushed me twice, but I didn't. I was too scared, and I didn't. It was happening so fast. I didn't necessarily use the word defend.
So when the tape was played earlier for the officer today, that wasn't on there.
I guess so. I'm not 100% certain because it did play the whole tape.
Never filed an eviction proceeding on her, correct?
No, because she wanted to avoid an eviction to help her credit.
Indicating right now, you said earlier she was gone for a day, but now you're saying it's 2 days.
So I do apologize. I did make a mistake. I've been sorry.
So testimony is she pushed you into the fireplace and then pushed you again.
She pushed me when she came to the door, and she pushed me into the fireplace again.
She headed down the hall and that's when you grabbed her.
There is not really a hallway in my house. It's just more or less an opening to the bedroom.
She headed close, so she was already past you.
So no, not necessarily, especially when she pushed me into the fireplace, she was not past me.
I'm saying when you grabbed her.
So no, she wasn't past me when I grabbed her either. She was right there, right with me.
Heard Mr. Stevens' testimony.
Yes, I did.
So the officer's mistaken about what you told her.
It's a possibility. I know there was a lot going on for that night for the officer and both me and the Lockwood.
You didn't hear that in the tape.
No, we'll take off the one like.
Correct.
Thank you, Your Honor. Katina, do you remember if you told Officer Johnson that you were pushed?
Yes, I do remember telling that.
Okay. May I approach, Your Honor?
You may.
Okay, so I am going to play for you part of your interview beginning at 1:10 in, okay?
Let me, because I think that we can't hook it up, let's stop that fan. Can you hit that fan so that you can hear better?
Sure.
Okay, thank you.
Lawyer, I was like, that's fine, you can call a lawyer and, you know, we can deal with it that way. So she comes and I open the door, I'm like, no, you can't come in. Like, you can come get your stuff pretty much, but you can't just like come in. And she like pushes the door open on me and then pushes me out of the way and says, yes, I am. As a matter of fact, I'm bringing my stuff.
All right, now you never said you were pushed into the fireplace, right?
No, I didn't.
Okay, but
I was pushed into the fireplace.
okay, but so you didn't tell Officer Johnson anything about fireplace.
Not the fireplace specifically. I told him about being pushed.
Now, did you know when you were speaking with Officer Johnson that I guess whether he'd already been to your home?
I did know he was at my home, yes.
Okay, and do you know? I guess did you have an understanding of whether he had been inside your home?
I didn't know he had been, if he'd been inside my home or not.
Okay. If someone were to walk inside your home, would they know where the fireplace is?
Yeah, it's right there at the door.
Okay, to the left of the door
Yeah,
when you're walking.
yeah.
Did were you bleeding at all from this scuffle?
No, I was not.
Okay, were you hurt in any way?
I was. I had bruises up and down. I believe it was my right arm.
Okay, did you document those bruises?
No, because I didn't know. I was.
Okay, sorry. And so you did not tell the officer you were bruised?
Correct, I didn't.
Okay, did you at some point document them in some way?
Yes, I did.
Okay, how did you do that?
As soon as
We
I got
approach, Your Honor.
You can proceed, Mr. Kuntz.
Took a photograph of bruises.
Yes, I do.
All right, and do you remember when that was?
It was probably about 20 or 30 minutes after I got out of jail.
Okay, following your arrest.
Yeah.
All right, so on April what?
I believe it was the night of April 13th.
Is when the arrest happened, so.
Yeah.
Did you get out the next day?
I did.
Okay. Did you at some point, and how did you took this photo with a phone?
Yes, I did.
Your mobile phone?
Yes, sir.
At some point, did you look to see I guess in preparation for trial, did you look to see when the photo was taken?
I believe I did. I believe I looked to make sure that it was taken quite soon after I got out of jail, but I'm not 100% sure.
Okay. Do you remember we met and discussed this over the?
Oh, yeah.
Okay. And did you look at the timestamp at that point?
I did, yes.
Okay, so was it shortly after you were released from jail?
Yes, it was.
Okay. Is this?
What are you showing her?
Oh, I'm sorry. I'm approaching with proposed exhibit B, Your Honor. This is not a quality photo, is that fair?
That is fair.
But is it a fair and accurate representation of the photo that you took?
Yes, sir.
Okay, and what is in this photo?
She grabbed me.
Where?
Right here, when she grabbed my forearm and she put me in the fireplace, and then I see this one is pushed through the door.
Okay, can you speak up for the jury?
Yeah, I'm
Okay.
sorry. The bruises on my forearms are from when she grabbed me and pushed me into the fireplace, and the one on my forearm, I believe, is where she had pushed me in the doorway.
At this point, Your Honor, I would move to exhibit defense exhibit B.
You may.
So you had a chance to review that photo, is that correct?
Yes, that's correct.
And anywhere on that photo, do you see a date or time stamp?
I do not.
So it could have been taken any time between now and then, is that correct?
I guess it could have, but.
Okay,
then
when did you
I didn't.
provide this photo to?
Your Honor, she's already testified that she reviewed when the photo was taken.
She did testify to that. I'll let him continue his voir dire.
And when did you present this photo to your attorney?
I presented it probably 3 days, not 3 days, let's say 2 days afterwards, after I got out of jail, because I hired an attorney that day.
Who was that attorney?
At that time, it was Matthew. Matthew has since left the office. So then that information was relayed over to Dustin.
So there's no time stamp.
There is not, I apologize.
I'm going to object to the mission. Just based on the fact that it's not even self-authenticated. She testified that she looked at some timestamp on her phone.
Okay, but she testified under oath as to when she took that picture, correct?
She did.
Okay, objections overruled, it's admitted.
Thank you. And so, your testimony is those bruises were caused by Karen Lockwood? All right.
Yes.
That's all I have for you, Katina. Thank you.
Did you want to, because he did go beyond the scope of your original cross, I'm gonna allow you to recross only as to where he went beyond the scope of.
Thank you, Your Honor. This photo you took.
Yes, sir.
These bruises could have just as easily happened when you grabbed her and punched her, is that correct?
No, because she didn't touch me after I punched her.
So when you grabbed her and punched her.
No,
And that would
she
be,
pushed me into the fireplace.
that would be this mark right here.
Incorrect, no. That was when she came in the door, is what I'm presuming, because that's where she pushed me. Yep, there's a mark there as well, because that's when she pushed me in the fireplace, because she specifically grabbed my forearms after I asked her to please not touch me.
How violently did she push you in the fireplace?
Pretty violently.
And those are the only little bruises you got?
That is all that I have.
And this is several days afterwards when bruising sets in.
So no, it was the next day.
So within a period of time, you allow bruising to set in.
Correct, because at that point, had it been over 15 hours since I'd been in jail. Yes, sir.
What arm is that?
That is my right arm.
Oh, any questions from the jury? Write it down. Hi, counsel. May this witness be excused from the stand?
Yes, Your Honor.
Okay, you may be excused, ma'am.
Thank you.
Okay, you can call your next witness.
No further proofs, Your Honor.
Okay, any rebuttal witnesses?
No rebuttal.
Okay, so it sounds like we need to take a recess and determine if we have to appear here tomorrow for deliberations or not, because I can't keep people here until 8 o'clock at night. So let's take a recess because we have final instructions, closing arguments, and then deliberation. So let's see where we are. And then we will advise you one way or the other how we're proceeding. All rise for the jury.